Good morning. It's my pleasure to welcome all of you here. I am Michael Hussey, Dean at Widener Law Commonwealth, and I am delighted that you are joining us for our 5th Annual Emergency Medical Services Law and Policy Symposium. It's really great to, again, have you all here to have these discussions. At the law school, we have a First Responders Initiative that supports our first responder law students. It's tailored to provide them with the academic, financial, and career advising that they need to be successful as attorneys upon their graduation. The law school is grateful to the law firm of Page, Wolfberg Wirth for sponsoring a generous scholarship to support our first responder students. And we really have an active student organization. This is law school is a great place to be. I'm not going to say anything nice about you, so don't worry. So Carrie's one of our students involved in all of that. But, that is creative in what it does. So about a year ago or so, we had a Veterans Association with a number of our veteran students in that, and some good conversations came out about that in supporting our fuller community of people that serve. So our first responders, as well as their families, spouses, significant others, that all contribute to what goes on here in serving the greater good, serving the public through EMS. And so I just bring that up as, what really makes our place here unique is that we're student-led. We're turned on that. They run with it. The Spirit of Service organization is doing great things. Carrie will probably sell you some T-shirts too at some point with a link if you're interested in that. But it's good to be here, to be innovative with Doug's sponsorship of what we do here and support for this. It's just really, really good for a school, that's committed to serving, committed to being engaged to have these opportunities. So thank you to all of you for your work on that. I'd like to thank Doug for working on putting together today, Professor, former Dean Christian Johnson, Corinna Wilson, Brian Fernbaugh running our tech for us, and all of the staff that has worked hard to make this happen as well. So we have a great symposium today, great speakers, and a lot of great topics to cover on that. So I thank you again all for being here. And now I'd like to invite Doug Wolfberg, class of '96, to come up and kick us off.
Thank you, Dean Hussey. Class of '96 sounds older and older every time you say that. So thank you to those of you that are here attending in person. Thank you to all of you who are attending on Zoom. I know we have a large Zoom attendance this morning, so we appreciate everybody's participation in this. I want to thank Dean Hussey for the steadfast support that the law school has provided for all first responders, veterans, emergency service providers, and continuing to hold this event. Now we're in our 5th annual, which time is flying. There's a bunch of other people that you're going to meet who are panelists, and they'll be introduced when their sessions occur. But I want to make a few other just quick introductions of some folks that are here with us. We have former State Fire Commissioner Ed Mann with us today. Nice to see you, sir. Thank you for joining us. We have President of the Ambulance Association of Pennsylvania, Gary Waters. Where did Gary? Oh, right there. Yeah, thank you for being here. And if anybody else is a notable, I really apologize that we didn't introduce you, but those are a couple of people that I did want to acknowledge being here. I also want to echo Dean Hussey's acknowledgement of Brian Fernbaugh, and I want to thank Brian and the whole staff here for everything they do to make this place run and to make this event run. So I appreciate all of their efforts as well. I also want to acknowledge the other symposium co-sponsors, that is the Ambulance Association of Pennsylvania, and you'll be hearing from their executive director, Heather Schrar, a little bit later, and also the Pennsylvania Fire and Emergency Services Institute, and you'll be hearing from their executive director, Jerry Ozog, a little bit later as well. And they have both been, I think, attendee or participants in this since the first year. So we've got this great core team and we really appreciate everything that they've done and continue to do. I also want to add my thanks to what Dean Hussey said, which is to acknowledge Corinna Wilson, who has been the coordinator of this event every year, and couldn't imagine doing it without you, Corinna. And although Professor Johnson can't be with us today, he is also a driving force behind this event, and his commitment to emergency services, communities, and veterans is unparalleled, and he's been a driving force for this, so I want to acknowledge him as well. Okay, so with that, we are going to hop right in. We're already 5 minutes ahead of schedule. Look at that, ladies and gentlemen. We are going to hop into the first topic here this morning, and that is the EMS homicide cases. And we're going to talk particularly about two EMS practitioner criminal prosecutions that are ongoing, in fact, that are scheduled for trial very shortly here, and I'll talk more about that, and take the lessons from those and just talk a little bit about what's happening. So I myself have been an EMS practitioner. I started in the late 70s taking ambulance calls, and then either as an EMS provider, a regional EMS director, worked at the state EMS council, federal government, and now as an attorney practicing in EMS law. I've never had a case or seen of a case anywhere where EMS practitioners had to face criminal liability for the provision of patient care, right? We've seen it for other things, stealing drugs or false billing or vehicular-related cases, but never related to patient care. And the fact that there's two of these prosecutions now going on at once is a bit chilling. And so it's important to talk about how these cases came about, what the legal theories underlying these prosecutions are, and to take a little look, a little bit of a look at maybe what implications this has on our profession. So as a quick overview, we're going to talk about the two particular cases, the Elijah McClain case in Colorado, the Earl Moore Jr. case in Illinois. We're going to take a look at the applicable law because this is a law school symposium. That's what we do. And then we're going to talk about this, what I think is sort of the key question here. When do acts of medical malpractice become murder? Because that's what we're seeing is essentially criminalization of deviations from medical standards of care, right? And that's really the key question. And then we're going to talk quickly about some lessons learned. So let me start with the facts of the Earl Moore Jr. case. And this case occurred, the operative facts were less than a year ago. We're still not even at a year since this happened. And this was in Springfield, Illinois. And on December 18th of last year, Earl Moore, who was 35 years old, was suffering from alcohol withdrawal and hallucinations. He was at a private residence. It was initially a police incident. Police were called to the scene. Police then pretty promptly called for EMS. Now, I'm going to show a few excerpts, just a couple of minutes of excerpts of body cam footage that was taken. A lot of this was on the news. Folks have seen this. But there's a compilation here, 3 or 4 minutes, of some of the key facts that you can see for yourselves. There were 3 police officers, each of whom had body cameras, and this is sort of a montage of those clips. So let's take a quick look at that.
It's police.
There's no one here with guns.
Okay.
He's hallucinating. He's having alcohol withdrawals. He's having drunk hallucinations. He called you guys for no reason.
Do you want us to talk to him?
He's seeing stuff that's not there.
Do you think he needs an ambulance?
Every time I take him to the hospital, all they do is release him.
Earl? It's the police. You called us, my man? You need some help?
48.
I'm sweating.
248 North 8th Street. 24.
Ambulance.
Someone get the phone.
You know where home is?
North 25th. Stay here with me.
Well, we're going to stay here, but you're not on North 25th. Let's start with this. Do you know what your name is? Can you give us that?
Earl 20.
What's up, bud? This is Earl. Haven't been able to get much out of him.
It's day 3.
He was up on his bed and he just rolled off onto the floor after he's been slowly stripping off of his clothes. What was his last name?
Moore. He's 35. He was born in March, but we don't have a exact birthday.
Earl.
What's your birthday, man?
Hey, it's his birthday.
This is about all we've been able to get.
Earl, sit up. Sit up. You know what? I am not playing.
Come on, Earl. Let's move,
up.
my man.
What happened, stupid?
Stop. Stop.
Sit up. Sit up now. I am not playing with you tonight. Sit up. What is your birthday?
March 22nd.
What year?
8. Earl, do you want to go to the hospital, man? We need to get up.
You're
All
gonna
right.
have to walk because we ain't carrying you.
So let's get up on your feet.
Because I am seriously not in the mood for this dumb shit.
You can walk. Come on. Let's stand up. Right.
No, we're just being lazy. Get up. If you're gonna go, you need to get up and walk.
Help me up. Let's go. Come on. Help yourself.
All right. 1, 2.
There you go.
There you go.
There you go. Come on,
buddy.
Keep it moving.
All right, we're moving. We're moving.
Let's keep going. One foot in front of the other. Come on, buddy. We got you. We'll hold you up, but you gotta walk forward. Whoop.
Come on, Earl, man. You gotta help us out a little bit.
Not that much further to go.
Right there. Right there. Keep going, buddy. Push. Now get up on there, man.
Come on, get up on there, old bud.
All right, Earl. This is getting a little silly, man. There you go. There we go.
So before we finish off the facts here, just anybody have any quick reactions they want to share? I mean, some of you have probably seen this video before, but any things that jump out?
Poor care.
Pardon?
Poor care.
Poor care. Well, those are two pretty apt words for that, right? You saw the EMT who entered the room here. Her name was Peggy Finley. You'll meet her in a second. Not in person, obviously, but she seemed a little bit more interested in her notebook, right? And making sure we knew his birthday. What's your birthday, right? Then can you breathe, you know? So there was really very little, if any, patient assessment going on here. So that certainly jumped out as a clinical matter. Let me ask sort of a more directed question. This is an EMS case that we're going to primarily talk about. But of course, when we see body cam videos in this day and age, we think police misconduct, right? And there have been a number of cases in the national spotlight. Does anyone want to share any thoughts about what they thought about the police conduct in this case?
They showed more compassion than the folks from EMS did.
Yeah, so certainly they're the only ones, and the comment was, just to repeat it for Zoom, that they showed more compassion than EMS did. And I think that's clear, right? They're the only ones who took any steps to move Mr. Moore. EMS didn't bring in a portable cot, a stair chair, or any portable moving device or lifting devices. Mr. Moore only got to the ambulance because law enforcement helped him get there. Anyone have any other thoughts about it?
Excuse me, Doug.
Yes.
Did she even bring in her first in bag?
No, all that I think was visible, and I think the evidence so far has shown that there was no equipment, no oxygen, no first in bag, just a notebook and a pen and a bad attitude were the only things that were brought into the house. Any other comments? Carrie?
The position they put him in for transport, and then the vigor with which they strapped him down.
Yeah, so she said the position in which they placed him for transport and the vigor in which they strapped him down, right? That's called prone restraint. When the patient is put in a face-down position, he's in a prone position. And one of the big clinical risks that's pretty well known with prone restraint is what's called positional asphyxia, where a person has their breathing compromised, not to get too deep into the medical weeds here, but that it is often a precursor to people losing the ability to breathe and going into either respiratory or cardiac arrest. I want to offer one other perspective about the conduct of law enforcement here. And again, we're not making this about the law enforcement. They were not charged in this case, by the way. However, the two practitioners, and we'll talk about that in a second, were charged with first-degree murder. If those two EMTs committed first-degree murder, did not 3 police officers stand by and watch first-degree murder happen? Right? Now, certainly if you're a prosecutor and you're trying to make a case here, you've got the attitude and the conduct of those EMTs loud and clear that you could take to a jury. The police officers do look compassionate. They do look courteous. There was a scene that wasn't in the clip. They offered him water, right? Boy, you're sweating. They call EMS very promptly. But what I thought was telling in this case is that the day these charges were filed, that I'll talk about in a moment, the Springfield Police Department released a press statement. And it essentially said, I'm paraphrasing, not quoting, our cops don't know anything about medical care. They relied on the EMS providers to take care of this patient. And we just, had no choice but to stand by and watch. It was a really defensive, blame-shifting statement. And folks, you do not need to be a healthcare practitioner to be able to see with your own eyes that what those EMTs were doing was wrong. Any layperson could make that determination. So I think ethically, I'm not suggesting they committed a crime, but I'm saying at least ethically, there was a failure of accountability, interagency accountability. If one of those cops would have pulled that EMT aside and said, yo, Peggy, take a deep breath. You're having a bad day. This guy's in distress. He needs help. Let's go back in there and take care of him properly, right? That would have certainly been ethically a proper type of accountability. They don't have to be trained and licensed medical practitioners to know that what was unfolding in front of them was bad news. So, and I think the same thing can be said when EMS practitioners arrive on a scene to find police brutality happening. Right? Interagency accountability. We saw that in the Tyree Nichols case, by the way. But let me get back on track with what happened to Mr. Moore. So there was only a short distance between that residence and the hospital to which Mr. Moore was transported, and it was only a 3 or 4 minute ride. And the records from the hospital indicate a, quote, resuscitation intervention upon ED assessment. That's the hospital's way of saying that Mr. Moore was in cardiac arrest and he required resuscitation. He was pronounced dead about an hour and 15 minutes later after all of this began at that hospital. Here is another clip, and I'm going to let Brian come back out because I know he needs to adjust one more setting so folks on Zoom can hear this okay. Yes?
Just a quick question. If this one that came out on body cam, how do you think this would have played out?
Yeah, that's a great question. Let me repeat that. If this wouldn't have been on body cam, how do I think it would have played out? The same way the tens of thousands of times it's probably played out before the advent of body cams, right? And I'll talk a little bit about that at the end because I think what happens in a lot of public safety organizations, not just EMS, but law enforcement, fire, and other public safety, there's a normalization of deviance, right? Whether it's because we're so up against the wall with recruitment and retention, and it's hard to find and retain people, whatever the reason is, I wouldn't find it at all surprising if the supervisors and coworkers of those EMTs saw that type of conduct many times in the past, right? And we allow it, we accept it, it becomes normalized. And it's, as I said, the normalization of deviance. So we'll talk a little bit about body cams at the end, but I mean, I think that's a key question here. So, all right, let's take a look at one other piece of evidence that came out shortly after these charges were filed.
I still have Harrisburg, 3.16. We are currently in under your facility. On board, I have a 35-year-old male coming from home, coming to you for evaluation of some alcohol withdrawals. Patient is slightly combative and confused. I'm not messing with getting vitals because I'm not going to poke the bear. He is conscious though, and we will be there in about 3 to 4 minutes. Do you have any further questions or orders?
No, we'll see you right in. Thank you.
Thank you.
So what you just heard was what we call the medical report that the EMT, Peggy Finley, gave by radio to the hospital, even though it was only a short 3 or 4 minute distance. It's to radio ahead, let them know you're coming, and essentially what they can expect. You heard her say, I'm not messing with vitals, meaning taking his pulse, respirations, blood pressure, because I'm not going to poke the bear. And she described Mr. Moore as combative. Now, you saw Mr. Moore about 4 minutes before he arrived at the hospital. That radio transmission occurred during that brief 4 minute span. He was clearly not combative at the time he was strapped to the stretcher in a prone position. And we know that he required resuscitation in the emergency department. So how he became combative when he was restrained in a face-down position during that 4 minute interval during the transport. And secondly, if you're going to restrain somebody in a prone position, which is not ever indicated, really, you triple check their vital signs. You don't say, I'm not going to check his vital signs when you chose to restrain him in a dangerous position, right? So I think that's another piece of telling evidence here. Here is the medical examiner, an excerpt of the medical examiner's report that was submitted a couple of weeks after Mr. Moore's death. Cause of death is compressional and positional asphyxia due to prone face-down restraint on an ambulance stretcher by tightened straps across the back and lower body in the setting of lethargy and underlying chronic alcoholism. There was additional findings in the autopsy of hemorrhagic non-displaced fractures of the left lateral third and fourth ribs. Again, not to get too deeply clinical here, hemorrhagic means evidence of new or recent bleeding, which means the fractures that were detected were new fractures, not underlying old fractures. Now, we do not know if Mr. Moore suffered a fall or any other injury prior to EMS arrival, but we saw on the video straps being applied to Mr. Moore with enough force to cause those injuries. So that's circumstantial, but that is a valid piece of evidence that can certainly be used. Okay? Let's take a look at the criminal charges in that case. January 10th, which was only 2 days after that medical examiner report came out, the state's attorney, the district attorney for that county in Illinois, Sangamon County, filed first-degree murder charges against EMT Peggy Finley, the one you saw in the residence interacting with Mr. Moore, and Peter Cadigan, the EMT who didn't say a word, but tightened the straps around Mr. Moore. The defendants were arraigned January 19th. Both have pled not guilty. I don't need to tell a room full of folks sitting in a law school classroom that folks are innocent until proven otherwise, but of course they are entitled to that presumption as well. On January 19th, the same day that they were criminally arraigned, attorney Benjamin Crump, who's in this picture, who's a well-known civil rights attorney who has been known to file a lot of these police misconduct cases around the country, filed a civil suit against the two EMTs and their employer, which is a private company, a private ambulance service in Springfield. Okay, let's take a look at the Elijah McClain case. and look at the facts of that. August 24th, 2019, Mr. McLean, who was 23 years old, was walking home from a convenience store. Let's take a look at what happened next.
It's August 24, 2019 in Aurora, Colorado. A security camera picks up 23-year-old Elijah McLean at this Shell gas station buying soft drinks and wearing a face mask. His family lawyer told NBC News he was in the habit of wearing this mask. At 10:30 p.m., a man calls 911.
Let me see, he has a mask on. He looks sketchy. He might be a good person or a bad person.
Yeah. At 10:43 p.m., Aurora police officer Nathan Woodyard spots McLean.
Do me a favor, stop right there. Hey, stop right there. Stop. 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 I have a right to stop you because you're being suspicious.
9 seconds after exiting his vehicle, the officer initiates physical contact.
You guys started to arrest me, and I was stopping my music to listen.
The situation escalates when the officers try to move McLean onto the grass. Officer Rodema says this.
Grab your gun, dude.
It's unclear from the body cameras whether or not McLean reached for an officer's weapon.
Hey, Rosenberg.
I'm so
For
sorry.
your gun, dude.
I have no gun.
That's where I tried prodding.
I don't do that stuff. I don't do any
We've
fighting.
seen other units that are not here.
Why
They
were
can
you
slow it down a
touching
little
me?
bit.
At 10:49 p.m., McLean throws up a first time. Over the next 4 minutes, McLean gets sick a few more times. At 10:54 p.m., McLean is still on the ground, and an officer says this.
So when the ambulance gets here, we're going to go ahead and give him some ketamine. Yeah, sounds good. Perfect. Let's give that a couple of minutes.
10:59 p.m., a fire medic administers 500 milligrams of ketamine to McLean in an attempt to sedate him. 2 to 3 minutes later, he is loaded onto an ambulance. And at 11:07 p.m., just over 20 minutes after the first officer made contact, responding officers are told McLean does not have a pulse.
He just cored. Are you serious? Yeah. Okay. So, sit tight.
McLean was resuscitated at the scene and taken to the hospital where he would be declared brain dead 3 days later.
So, anybody have any initial thoughts, reactions to what we just saw on that case? Anything that jumps out? Carolyn?
Why are you giving ketamine to a human? Animal tranquilizer.
Well, so the question was, why are you giving ketamine to a human? It's an animal tranquilizer. So ketamine, and we'll talk a little bit more about this, is an approved drug for use in humans, and specifically it's approved for use in EMS. Now we're going to talk about a state law that narrows the use of that, at least in the state of Colorado. But ketamine has become part of the pre-hospital pharmacology. So for better or for worse, but that drug is certainly becoming a poster child for bad behavior. We'll talk a little bit more about that. Other things that jump out. Gary.
Was there any assessment or vitals before they administered ketamine?
So interestingly, the question was there any assessment or vitals taken, blood pressure, pulse, respirations, before the paramedics arrived and administered ketamine? I think the evidence suggests that there was not a robust assessment. And as a corollary to that, right, you heard one of the police officers say, when the paramedics get here, we're going to go ahead and give them some ketamine, right? That is not a law enforcement determination to make. And without commenting on the evidence, right, paramedics certainly shouldn't administer ketamine simply at the direction of law enforcement or any drug or any medical intervention. It may be that the intervention is appropriate, even though law enforcement says we want you to do X, right? If the clinical assessment determines that that is an appropriate intervention, then fine. But if the sole reason any healthcare practitioner administers an intervention is simply at the direction of law enforcement, we've got ourselves a problem, right? Because we owe a duty of care clinically to the patient, not to assist in detaining or subduing a suspect, right? That's not what EMS does. That's not what EMS interactions are for. Yes, sir, Matt.
Just a general question. Once the police got him onto the ground.
Sorry, I'm saying?
When the police got him onto the ground.
Yeah.
Was he still actively fighting? I didn't see a lot of that. So I guess my question would be is why are you administering ketamine to someone that's really I don't want to say, from what I saw, non-violent at this point?
Yeah, so the question was Mr. McLean still actively resisting or fighting when he was taken to the ground? he was subdued pretty quickly, right, and restrained by law enforcement. In fact, they also applied what's known as a carotid hold. And in this case, 3 police officers were also charged, and I'll talk about the disposition of those cases here in a moment. So they used physical restraint techniques prior to arrival of EMS. Mr. McLean was about 125 pounds, I believe, so he was not much of a match for the police officers in this case. Anything else that stands out or anybody else wants to comment on before we... Sir?
The dosage is way too high.
So another element of this case is that Mr. McLean was dosed at 500 milligrams of ketamine. I'll talk a little bit about that. One of the allegations in the case was that if ketamine administration would have been appropriate, and that's one of the questions in the case, the correct dosage would have been 325, not 500 milligrams. Now, folks, I'm a former EMS provider, which means I have just enough medical knowledge to be dangerous, but I have served on a few panels on ketamine at national EMS conferences and events with researchers and clinicians who have studied this pretty closely. And the evidence that I've seen in these panels and presentations and stuff that I've read is that that difference in the dosage of ketamine is not likely to be fatal, to cause death. But certainly this individual had a carotid hold applied to him prior to the administration of the ketamine. And we're going to talk in a second about the conflicting findings in this case from the medical examiner. So let's sort of take a look at that. Ma'am.
Are we going to ignore the race politics in these 2 cases?
Oh, no, not at all. We're going to cover it. And, you know, and to comment on that now, folks, is it a coincidence that both Mr. Moore and Mr. McLean were black and the police officers and clinicians were white, right? There is an unavoidable racial component to these cases, right? Similar to what we see in the police misconduct cases, whether it's George Floyd or whether it was Eric Garner or whether it was certain others. Now, however, in the Tyree Nichols case in Memphis, many of the police officers involved in that were black, right? So we're going to talk a little bit about bias before we're done here and the absolutely undeniable role that is likely to be playing.
I mentioned that as the only black person in the room.
Yes. Yes, thank you. And for those on Zoom, the questioner added that she's the only black person in the room, which is true. Was there another? Yes, Corinna.
Yeah, Doug, from online, a commenter, there was no actual crime reported. Police should have asked more questions first. The approach was too aggressive.
Yeah, so the comment was that there was no actual crime, that police were unduly aggressive in their confrontation of Mr. McLean. Certainly 3 police officers in that case were also charged with homicide, and I'll talk about what happened in those cases. But certainly principles of de-escalation and confrontation were all mismanaged, you know, in my view in this case, and I think it's apparent on the video. And keep in mind, this was 2019. The fact that Mr. McLean was wearing a mask at that point pre-pandemic, right, was seen as that alone was seen as suspicious. I have a right to stop you because you're being suspicious, right? Simply walking down the street with a bag of groceries wearing a mask. So there's a lot of issues regarding the policing and the stop of Mr. McLean in this case as well. Now, the initial medical examiner's report in this case that was done at the county level concluded that the cause of death was undetermined, could have been, this is the conclusion, right? Not a very strong conclusion, could have been intense physical exertion combined with a narrow coronary artery, right? Think what you will of this report, but it sort of seems like we're trying to find any reason other than police and EMS interaction to attribute to the cause of death here. Now, interestingly enough, 3 years later, a second medical examiner report was issued at the request of a state grand jury, okay? It did not involve physical autopsy or examination. It went off of the records of Mr. McLean's death. That second report determined that the cause of death was complications from ketamine administration following forcible restraint. The manner of death was determined to be undetermined instead of homicide. Now, folks, cause of death is, for example, in this case, you know, as you see, it was complications from ketamine administration, which is a point that will be debated in the trial. But for example, if a patient dies of a gunshot wound, the manner of death could be homicide, right? It could also be justifiable. It could be a case of self-defense, for example, right? So cause and manner are two different things. That initial decision was made by the county prosecutor in the county where this took place, concluding that no criminal charges were warranted against either the police or EMS providers in this case. And quite unusually, the prosecutor issued a detailed written report explaining his reasons not to prosecute. Usually, a declination of prosecution is not accompanied by a written report on why that decision was made. In this case, that decision was made, and a written report explaining the reasons not to prosecute was issued. Now, of course, given the social justice movement, right, there were protests. The George Floyd case occurred in between here, right? So social consciousness was certainly being elevated on these issues. The state then convened a grand jury. State grand jury indicted 3 police officers and 2 paramedics after the county prosecutor had refused to bring those charges. Each of those 5 defendants were charged with manslaughter, criminally negligent homicide, assault with a deadly weapon, ketamine, and conspiracy because there were multiple parties involved. These are the 5 defendants. The prosecution's theories of criminal liability in this case against the EMS providers are novel, and I want to take a quick look at those. One of the key allegations here, or theories of prosecution, is that their determination by the paramedics that Mr. McLean was suffering from excited delirium was an inaccurate diagnosis born of the paramedics' failure to adequately assess Mr. McLean's symptoms. Now, earlier Carrie asked, did they assess him at all, right? One of the key allegations is that the paramedics did not adequately assess Mr. McLean prior to administering the ketamine. And in light of that inaccurate diagnosis, ketamine should never have been administered, right? So this is a key issue, and we'll talk about the implications of that in a second. There was also an allegation that Mr. McLean was inaccurately dosed, that they misestimated his weight, and that given his actual weight, the dosage should have been 325 and not 500 milligrams of ketamine. And here is where this theory really gets novel, and that is that because the medics deviated from their medical protocols that were in place at the time to govern the administration of ketamine, that the administration of the ketamine under these circumstances became unlawful. Not a medical error, but unlawful. That in essence, they were simply grabbing ketamine from the drug box to subdue a suspect, not to administer a clinical intervention, okay? So if those theories of the prosecution prevail against the EMS practitioners, this would be the first case that I'm aware of that criminalizes acts of medical protocol deviations. And when healthcare practitioners deviate from medical standards of care, we call that malpractice. And that's why we're going to get into, in a few minutes, this line between medical malpractice and criminal liability, okay? Because we're seeing that line start to erode. There was also a civil case. The city of Aurora paid $15 million to settle the civil case. According to this headline, one of the largest police-related settlements in U.S. history. All right, let's take a quick look at the status of both cases. The cases against the EMTs in the Moore prosecution and the cases against the paramedics in the McLean prosecution are both pending. It is 100% coincidence. Both are next scheduled for activity on November 27th, scheduled for trial to begin on that date in both cases. Now, there may well be continuances, which is the legal word for a delay, but they are both on the docket to be heard starting on November 27th. There have already been 2 prosecutions in the McLean case. 2 officers were tried together in the first trial. 1 officer was tried separately in the second trial. In the first trial, there was a split verdict. 1 officer, the supervising officer, was convicted. The other officer in the first trial was acquitted. The officer in the second trial, who was tried alone, was also acquitted. So thus far, there has been 1 police conviction, 2 police acquittals. Can anybody guess what one of the key defenses in the legal defense of the law enforcement officers' criminal cases were?
No medical knowledge, refer to EMS.
Pointing the finger, ladies and gentlemen, putting EMS providers squarely under the bus for the administration of the ketamine that you heard the police officers say they wanted the paramedics to administer. We're going to go ahead and give them some ketamine, right? So I find it interesting that, there's this tight relationship oftentimes on the scene between law enforcement and EMS, and I'm not besmirching that relationship. Most of the time, it benefits the public that EMS and law enforcement can work together for the safety of the responders, the safety of the scene, the safety of bystanders, safety of the public. But in some cases, that relationship gets toxic. But when it was time to mount a defense, the finger was squarely pointed at the paramedics in both law enforcement officer cases. So the one officer who was convicted is scheduled for sentencing on January 5th. Now, there has certainly been fallout from this case, and the alliteration of this phrase occurred to me earlier this year after these charges were filed, from stars of life to prison stripes, right? These are the 2 EMTs in the Earl Moore case, Peggy Finley and Peter Cadigan, taken at their arraignments in January. And, EMS has generally been viewed favorably by the public when it comes to admiration for what EMS and fire responders do. But these cases have brought EMS into that same uncomfortable spotlight, and maybe long overdue spotlight, that police has been under for years, right? Because the public is starting to fast forward those tapes, those recordings, when they see police misconduct and say, well, what happened next? What did EMS do when they got there in these cases, right? We saw in the Tyree Nichols case, for example, a person in handcuffs leaning against a police car, obviously injured, and the EMTs and medics just sort of hanging back, right? Not to interfere with what the police were doing. Again, a lack of interagency accountability by not aggressively interceding to treat Mr. Nichols in that case as a patient. And again, that's where the horrors of implicit bias come in. And I'll talk a little bit about that at the end. But if we see a person in handcuffs leaning against a police car and we immediately assume that's a bad person, not deserving of our best efforts medically, right, then that bias leads to these kinds of tragic outcomes, right? So we'll talk a little bit about that again before we're finished.
Question.
Yes, sir.
How much of this do you think has to do with the way that we view our role, right? And what did I mean is, there's a struggle, right? What are we? Are we public service or are we medical practitioners separate to that, right? Is our relation to the police, right? Do we follow what they're saying? How much do we take independently? And I think a lot of that has to do with the culture and each organization, right? And I can understand how fire department personnel may take the word of the police even if it's incorrect, right? And I think that we still struggle with that mostly throughout, at least the United States. What is our actual role and where do we really fall?
Yeah, let me repeat that and just summarize. How much of this, the question asked, is due to the fact that EMS is often part of public safety or viewed as public safety versus healthcare? And certainly, he also said when it's fire-based, there's that even closer relationship. Oftentimes, these departments are under the same jurisdictional umbrella. I think that's an outstanding question because I think this age-old debate of whether EMS is public health or public safety, it's healthcare or public safety, I think that ship has long since sailed, right? We deliver healthcare. And I've said in other lectures that imagine how public perceptions of what EMS does would change. Instead of showing up in ambulances with red lights and sirens and uniforms that look like, public safety, we showed up in a nondescript white van with a stethoscope around our neck and a smock on, right? Now, I'm not saying, this is how we should all dress, right? But what I'm saying is we need to make it clear that what we do is deliver health care. We are not here as adjunct law enforcement agents. We may have a public safety role, right? No escaping that. But EMS practitioners, and that's why I've been deliberately using that phrase, by the way, EMS practitioners, because we deliver health care. And our job is not to subdue or detain or assist in arrest, right? And I think that is an absolutely fundamental question. How we perceive ourselves, how other public safety agencies perceive us, one of them, right? And how the public sees us. And I think that's foundational, honestly. So thank you for the question. Yes, Corinna.
Follow-up question to that from online. How does the interagency responsibilities apply related to laws and regulations defining those interactions, such as MPA?
Yeah, the question is how do laws and regulations apply to that interagency accountability, specifically asking how would that play out in Pennsylvania? Folks, there is very little legal guidance that says here's who's in charge of a scene, right? We've actually written and lectured about that. There is no clear point in time at which a law enforcement suspect becomes an EMS patient, right? There's no clear line of demarcation as to when that legally happens. It's generally governed by tort standards of care, right? But I will tell you that on a practical basis, and I know a lot of EMS responders in the room, right? The people with the badges and the guns are usually de facto in charge. Because if a person is in police custody or sitting in the back of the cruiser, it's not like we can just go open the door and take them out and put them in the ambulance. There needs to be a degree of law enforcement cooperation to allow access to that patient if they are in custody, right? Or under arrest or whatever the case may be. There's a group, by the way, that I want to mention out of Harvard that we've been working with called the Medical Civil Rights Initiative. And they are promoting legislation in various states that if enacted, would clarify the right to medical care of people under arrest or in custody. And that initiative is really sort of helping to lead the way here because that is kind of the black hole of accountability, right? Whose patient is this? Is it their suspect or my patient? And there's very little clear delineation of that. And I thank the person on Zoom who asked that question because that is also a key issue that is raised by these cases. And as I mentioned, these other cases have also brought this into scrutiny, right, with the conduct. Yes, ma'am?
On that subject.
Yes.
I'm on the EMS, I don't know, and not this area of the law, except what I've learned in these seminars over the years. But you said that if the EMS people are responsible for health care, how does the ketamine play into that? Because isn't that just used to do rather than to be part of the healthcare treatment of the patient?
Yeah, the question was how does the ketamine play into that? Because isn't that used to subdue rather than to provide treatment? So I know again we've been talking a little bit about the role of ketamine. Ketamine is an approved drug for clinical uses. It does have clinical indications. I think the underlying case issue here was that it was used not for clinical purposes, but to subdue. It certainly has that effect, okay? And I'm going to talk in a moment about a law that was passed, right, to curtail the use of ketamine in these certain situations. Nice segue, I'll do that right now, right? In 2021, the state of Colorado enacted a statute, this passed, was signed into law, prohibiting the use of ketamine in the presence of law enforcement unless certain criteria are met. The default is it may not be used by paramedics in the presence of law enforcement unless one of the enumerated exceptions in the statute exists. So that law is now on the books in the state of Colorado. Personally, folks, I have a little bit of a problem when state legislatures start legislating scope of practice and standards of care. But this is the response that we can expect, right, when we do not meet the public's expectations. The political branches will get involved, and that's what we saw. Now, we've also seen national groups and some states, by legislation, ban the use of the excited delirium diagnosis. So the use of ketamine and the diagnosis of excited delirium have both been things that have been specifically looked at by policymakers in the light of this case. National Association of Medical Examiners has also recently released a statement prohibiting or excluding the use of that diagnosis. Okay, let me take a quick look at the laws here, and I'm quickly running out of time, but I do appreciate all the good questions. In Illinois, the law, and this has come under a lot of focus, right? Because a lot of folks think, well, it's intentional murder or premeditated murder. In Illinois, the law has 3 criteria for first-degree murder. Intends to kill, not applicable here. Knows that such acts will cause death, questionable here. Or, here's the third criteria. Knows that such acts create a strong probability of death or great bodily harm. So the prosecutors, I don't think, are going to have a viable case to prove that they intended to kill Mr. Moore. I don't think that they're going to have a viable case to prove that they knew their actions would kill Mr. Moore. But on that third criteria, they knew their actions created a strong probability that Mr. Moore would die, or suffer great bodily harm. We've already talked about the fact that lay people, and believe me, police officers through their training also know that positional restraint, prone restraint, can lead to that type of positional asphyxia. That's pretty much in the common knowledge, and believe me, police officers know that too, right? So on that third criteria, whether we agree with this prosecution or not, the prosecutors have a case, and we'll see what ultimately the jurors have to say about that. Colorado, 2 paramedics and 3 police officers were charged with manslaughter and criminally negligent homicide. Manslaughter, recklessly causing the death of another. Criminally negligent homicide, causing the death of another by conduct amounting to criminal negligence. So that is a lower burden of proof, folks, than first-degree murder, okay? So let's quickly visit this question of when malpractice becomes murder. Remember, these decisions are made by prosecutors who are local elected officials, right? So these are not decisions made in a vacuum. These are also political decisions. In this case, in the Moore case, the prosecutor received the medical examiner's report. It showed the death by positional asphyxia. The DA then has to determine if that death is justifiable. Some homicides are, self-defense, for example. If it wasn't justifiable, the DA then has to decide who's responsible. They're going to look at the law enforcement reports and all available evidence, including the body cam footage that we saw. Then, of course, they have to determine if there was a guilty act, the actus reus, the guilty mind, the mens rea. Anybody who's watched Legally Blonde very well knows mens rea, right? And then the DA has to decide what level of charges are most appropriate and what they can prove to a jury, okay? Now, under mens rea, the guilty mind, we do categorize crimes and offenses by the state of mind of the actor when they commit that. And if that sounds a little dystopian or Orwellian, right, this isn't new. This is what the law has always been. Punishments are more severe for more guilty states of mind. Negligence is unintentional. It's a mistake. It's an accident. And that's why we call malpractice, right, medical negligence. Gross negligence is beyond simple or ordinary negligence to recklessness, carelessness, extreme disregard. But that is still civil. That's still a civil law concept. Now, intent is willful and purposeful commission of an act in violation of the law. Prosecutors do literally have to make those determinations to essentially assess the state of mind of the defendant when they committed the act. We already talked about the effect of body-worn cameras. We have police body cameras, which were in evidence in both of these cases. More EMS agencies are adopting body-worn cameras. We have traffic cameras, which became an issue or piece of the evidence in the Tyree Nichols case. Crime prevention cameras. We have private cameras in residences and businesses. We have bystander cell phone cameras, right? So all of these are pieces of evidence that prosecutors are going to look at. And when they see aggression, lack of basic patient assessment, mistreatment, prone restraint, when they hear hostility, anger, antipathy, disregard, as I think the video showed pretty clearly when Peggy Finley entered Mr. Moore's room, right? it becomes easier for them to see that guilty mind. They don't have to guess or make suppositions. They can see it and hear it. And EMS practitioners have a duty to accept patients on their terms and on their time, a duty with which it appears the EMTs in the Illinois case certainly failed spectacularly. And we need to address root causes, right? And I was asked earlier about the role of race in these cases. I think personally, this is my opinion, that it is an undeniable role in these cases. And I think too many EMS agencies have not adequately prepared and trained for addressing issues of implicit bias or even conscious bias. I mentioned earlier the normalization of deviance, organizational culture. I personally also believe there is a provider health, mental health, wellness aspect to some of these cases, whether it's burnout, whether it's other aspects that aren't being adequately addressed. And it is the reality that in many cases EMS is used as sort of a primary care safety net or addiction or substance abuse, right? When there aren't sufficient resources, or maybe there are, but the individuals involved in these cases don't have access to those resources. First thing you heard the person who came to the door when the police arrived at the Earl Moore residence, or it wasn't at her residence, do you want him to go to the hospital? Every time I take him, it's the same thing. They just send him home, right? So there are clearly primary care failures here that the public is expecting EMS to fulfill. So there are both organizational and systemic issues that have not been adequately or properly addressed in some of these cases. But the key one that I take as a lesson from this is the need for training on implicit bias and to recognize that we all have those. Not a human failing to have biases. It's how we process information quickly in some cases. But when those biases become a foundation of how we treat patients, there is clear, and this isn't just me being woke or whatever, folks, there is clear clinical evidence that there are disparities in care, particularly when caregivers are of one race and the patient is of another. Pre-hospital use of pharmacology, of analgesics to control pain, recognition of certain kinds of heart attacks called STEMI, recognition of strokes in the pre-hospital setting. All of these have well-documented disparities by race and underserved populations. And those are, I think, key takeaways in these cases. Ladies and gentlemen, I have exceeded my time here by a couple of minutes, so we will have some additional time for discussion, but I appreciate all of the questions that folks asked thus far. Mr. Lyle, I think you are next up. So while Steve is, I will introduce our next speaker here in a moment. Any just remaining, lingering, burning questions while Steve is making his way to the podium? Yes, sir.
You made the statement about burnout, and this is something you could spend hours talking about. I mean, you have ambulance services that are understaffed, people working overtime because they're understaffed, so on and so forth. And I really think, and I'm not using this as an excuse for the behavior, but those first two EMTs, if you looked at the underlying cause, how long had they been working, et cetera, et cetera. So you know, the mental health aspect is something I think we all overlook, whether it be with police, fire, EMS, that it's the burnout. And again, I'm not using it's not an excuse, but it's something that we need to pay more attention to.
Right. So the comment was that, you know, because I'd mentioned EMS health and mental health and wellness, the commenter said that, you know, this may well have been a clear case of burnout, and that it's likely that the mental health needs of those clinicians were not adequately attended to or addressed. And he was also careful to add that that is not an excuse for the behavior and the conduct that we saw in those videos. And Commissioner, I couldn't agree more. So thank you. Okie dokie. Now, I have the great pleasure of introducing our next presenter, Steve Lyle, who is the Executive Director of the Emergency Health Services Federation, who is going to provide a EMS regulatory update and also give us some tantalizing visions of our EMS future that we talked about a little bit before the session this morning. Steve, the Emergency Health Services Federation is the recognized regional EMS council that covers the South Central Pennsylvania area. So he is our local EMS regional director. Also one of the longest serving regional EMS directors in the Commonwealth. And personal commentary, I also believe, one of the most enlightened regional EMS directors that Pennsylvania has. So, Mr. Lyle, the podium is yours.
Thank you.
Thank you, sir.
You know, it's always good following a national speaker. And as you can tell, we have $80,000 worth of high-tech equipment here, and I'm still using legal pads and paper, so bear with me. Doug asked if I would give a regulatory update, and I must say, that's like talking about my mother-in-law. I can say that now. She's passed on, so there'll be no retribution. I'm a steward for the EMS system of South Central Pennsylvania. That's how I look at my role. I'm fortunate to be in this role as a past dispatcher, as a past EMT paramedic. I live this stuff. So when we watch the videos that Doug shared, you know, the question that I am going to ask is what regulation, what policy would have prohibited that? You can't regulate everything. So we have to look at things, I think, a little bit differently. So let me tell you where we're at. We currently operate under an EMS Act. It's the second EMS Act since I started in EMS. This is Act 37. And it lays out how we do our job, the minimum equipment we need, the minimum training we need, what occurs with investigations, and those types of things. We also have the providers who have to operate underneath a scope of practice. There's a national scope of practice that tells the EMS providers what skills they're capable and allowed to do. Pennsylvania adopts their own scope of practice, which lines up with the national practice in a lot of ways. But of course, we're Pennsylvania. We don't line up perfectly. We also have state protocols, and I don't know if you know it, but the state protocols defines the treatment algorithms that we go through. We made the decision years ago that we were going to update those protocols every 2 years. So we've adhered to that pretty closely. Going through the process this year was really interesting because there was a new angle that was placed in our draft protocols. And in short, it stated if you deviated from these protocols, we're going to consider it patient abandonment. The protocols when I started were 8 pages. I think the protocols now are 30 pages. What we're trying to do is we're trying to police and regulate good treatment. Again, I'm not a believer that I believe we can enforce minimums, but I don't believe we can enforce best practices. I believe it's a dangerous thing point that we're at if we're going to start trying to find ways to hold providers accountable, again, thinking that that's going to improve care. I was part of the EMS system back with the first EMS Act, Act 45, and that lasted for years and years. What happened with that was the needs of the community, the needs of our system started changing so fast that we would be waiving a certain part of that act almost monthly. We would find a different thing, that a new pressure, or new technology, if you just think, you know, of the technology changes that occur and how quickly they occur. So the idea was let's build a new EMS Act. The EMS Act process, it was interesting to watch, interesting to go through. My friends were all on the committee to develop the protocol, had a lot of input into that, and I got a lot of feedback from that. And we were so excited about the fact that what we were doing here was we were going to lay a good floor. That way, any changes that would need to be made, because again, this was 2007, 2008, 2009, we were sure that between then and now there would be a change or two needed. Those changes could be done via policy or maybe even the regulations, but the act would be good. The act would be a good basis for us to jump off and make those changes. I think what I missed in that, and I learned this more this year than in my 40 years, is how a law is written is, obviously very important. The specificity within a law is obviously very important. But what I've just put my arms around, it's in the interpretation of the law that is, I think, most important. We're in a law right now that was implemented in 2009. I've been doing what I've been doing for a long time. I can't keep up with the different changes of perspective from our regulators right now, and how do I advise our EMS providers as to the new interpretation of a law that has existed for 15, 20 years now. I don't know what the answer to that is, but I find I can tell you what I have learned is I have learned that if we're going to rely on legislation to define how we do our jobs, this is what we're going to get. We're going to get the latest interpretation by the person who is the chief regulator. I will say that the announcement came out this week that we have a new state EMS bureau director, Anthony Martin. I know Anthony personally, and at this stage of my career, I can't tell you how inspiring it is that they selected somebody of Anthony's background, of Anthony's character, and from Pennsylvania. I think that's huge. The act, the law, and the regs can be very specific, but what they can't do is they can't help us address the more complex issues. The treatment, the apathy, the empathy that those providers had. How do we use a law to change that? Here's an example. Is an ambulance in your community that is the doors are only open 50% of the time, is that a good thing or a bad thing? If it's a bad thing, let's put it in law that says you can't do that. Oh, we do have that in law. Is that a good thing or a bad thing? I would offer that it depends. In the city of Harrisburg, I don't think it's a good thing. In Blaine, Perry County, I think it might save lives. How do we get from having a law to having common sense? How do we get from policy and regulations to having a common sense way to address complex issues? I'll tell you how we do it. We find leaders. And a lot of the people in the room here I've seen at different events over my career, and EMS has a history of looking to others to define our profession. The question was asked earlier, are we public health or are we healthcare or are we public safety? I was really happy to hear Doug say that we're absolutely healthcare. We are the most basic part of public health. I don't know why that's complex. We are public health. You can't get any more public health than to provide healthcare in somebody's living room, in their personal space in their bedroom. There's a lot of trust that goes on with the EMS providers, and as Doug showed, we're well thought of until we ruin it. But we're going to ruin it if we don't take control of our own profession. The law students who are part of this discussion, I think the thing that is holding us down to any kind of innovation, any kind of growth, Doug and I joked about this earlier, is the threat of liability. To be honest with you, we don't know what we're talking about. Every change I've tried to make since 1994, I'm met immediately with, well, where's the liability? Who's liable? What I would ask is the students, the law students who are part of this discussion, please consider how you can have your profession assist us through that. What we need is lawyers who are going to be advocates for us. Doug and Steve and the group, that such a rare thing in the United States. It's why they're nationally known, because it's such a niche where we go out to the scene and we're thinking about the lawyers in a way to protect ourselves, not that we have a partnership. I really think, and I want to talk a little bit about innovation, as I try to include a new system model, if you will, my biggest barrier is going to be getting through the liability scare of all, not just the public safety, not just EMS, but the municipal government, the county governments, and state government. The difficulty to find vision in EMS is that we are, and have for our history, been a 100% response force. In fact, behind the walls, we say, you call, we haul. I can see it administratively. If you have a provider, a paramedic or an EMT, and you say your certification is up in December, I'd like you to go ahead now and get that fulfilled. It's almost corny in our office how even administratively, the activity occurs the day before the deadline. And my staff, they pull their hair out, and I say, they're responders. They're responding to a deadline. They're responding to a limitation in the law. So as I try to find folks to champion a vision, to partner with me in a vision, it's really tough. Even our most seasoned EMS leaders, they're so focused on, how do I get the truck out? How do I increase membership? How do I pay the bills? So to get them to have a vision of what it looks like in 3 and 5 years, it's really difficult. I recently watched something on TED Talks. I don't know if any of you ever watch things on TED Talks, but it's really a neat vehicle for you to gain a new perspective on things. And I would challenge that there's a guy named Simon Sinek, and his topic is starts with why. Find your opportunity and look at that TED Talk, because it really speaks to the fact that even the EMS providers, we all know what we do. A couple of us know how it's being done, but very few know why. My wife, for Thanksgiving, will make a turkey and a ham. And when she makes the ham, she cuts the end off of each part of the ham. And last year I said to her, Lisa, why do you cut the ends off the ham? And she said, well, my mom did it. So I go to Linda, why do you cut the ends off of the ham? And she said, well, my mom did it. So I went to Mary, 96 years old, decrepit. I said, Mary, why do you cut the ends off the ham? I don't have a pan big enough. That's such a corny story to say, that's where we are. We are doing the same thing in EMS today from a model perspective that we did when I first joined in 1981. You call 911, and by the way, I was a big pusher of 911. Everybody call 911. Well, people listen, because now we get calls from 911 for, is the post office open on Veterans Day? It's incredible. You would never believe it. But the idea is, you call 911, we send you an expensive ambulance, $200,000 ambulance, and we take you to an ED. That's it. Then we go to the next call. Well, it doesn't matter if you have a cat bite or a coronary. If you call 911 1 minute before with your cat bite, 1 minute before I call with my coronary, who's getting the ambulance? The cat bite. We first come, first serve. Now, again, in 1970, that made sense. You had to call down through the phone tree, and people didn't use 911. People didn't use it unless it was something serious for the most part. So now what we have is we have continued to cut the ends off of our ham this many years later. And, I challenge that I can't help it. I spent a little time in the insurance industry, and seeing the providers here and the activity of those providers, I can't help but to feel that we owe them a little bit of something also. They are the worst example of us doing care. We saw them on their worst day, you could argue. And the reason is, in part, is you only have so much empathy, so much compassion that you can share. And I think if that's not re-energized, I think you run out. So my point with this is, we have these providers who are trained to do, to restart your heart. They're trained to fix a collapsed lung. They're trained to help you in the middle of your heart attack, and yet we have them running on one non-emergent call after another. I would offer you that of 100 EMS calls, maybe 15 are critical enough that time means everything to get those patients. So if what I'm saying is accurate, doesn't it make sense for us to build a better model? I think if we build a better model, perhaps we can focus on the patients that you saw them treat and build that education that Doug's talking about to teach them. I don't know that you can teach empathy, but integration into different cultures and the more complex issues. Right now, you ask the average EMS educator, the average EMS manager, they don't have time to teach all this. They have to teach how to fix obstructive airway disease. They have to figure out how to, and there's so many things, and it sounds gimmicky and it sounds like an excuse, but I'm giving you, I don't look at it as an excuse, I'm giving you a reason. It's a reason why we need to change our system. If we continue with, you run, everybody who calls 911 gets the same resource repetitively, you can't, it's human nature. These folks who I want them leaning forward. When they have a large vessel occlusion in the brain of a 50-year-old, I want them leaning forward. Do you know right now the time on scene is the same for a large vessel occlusion as it is for a nosebleed? Why is that? Because they run 100 calls where the time doesn't matter. They're human beings. They get into that space of, they'll go in and associate with the family. And so when they have a critical call, it really takes a special person to be able to change and pull out. When I was a field medic, I was on a squad with 2 other medics. I think that's a sign of how weak of a paramedic I was. But we would respond to only serious patients. I had the best upbringing in EMS. I was spoiled. We had BLS crews of 4 EMTs who would show up and begin care. We would show up with a couple medics. And I can tell you, in a 20-minute transport time, I didn't get done everything I needed to get done. So I don't want to ask the questions about how are we getting all that we need to get done now, because I think I know the answer. But I can tell you that I got better because I was postured to be aggressive the second I got on the scene. We're asking these folks to handle every type of event, and the most critical patients are the ones they see the fewest, and I think that they're least postured to treat. What can we do about that? Well, here's what my vision, and Dean, I love the word innovation that you used. I think that's where we have to live. I think that we have to live with innovation, and in the last handful of years that I have to work in this profession, I want to take the biggest swing, and I believe in our region. What we're going to do is we are going to interrupt the system. We're going to put nurses in the triage lines, or maybe even medics. I don't want to get crazy here, but we're going to put what I'll call navigators in the 911 centers. We've been in discussions with 2, one of which you're sitting in right now, where we can begin to have that person sit inside that 911 center, intercept those calls, or using the emergency medical dispatching that we've had since the 90s, we could triage that patient initially and have them sent to this nurse so that there could be some guidance that perhaps that person doesn't need an ambulance. And perhaps that person doesn't need to go to an ED and sit for 4 hours. Perhaps. The other thing that we have is it kind of feels like, and I've heard the old timers say this, and it strikes me now that I'm an old timer, that everything comes full circle. And when I started, we were all volunteers. A paid paramedic somewhere was an unusual thing. They were out there, but it wasn't a core. We're now a career force, and we have dismissed almost totally, in my region, volunteers. So what I think is cool is there are volunteers. In fact, I have, under my coordination, I have a couple hundred Medical Reserve Corps members These are just good human beings who maybe had a medical career and have retired and still want to feel value and still want to make an impact. And I think it's pretty cool that they're open to maybe helping us fulfill a couple different parts of our system. I want to refocus our system back on the most critical patients. I think it's okay for us to not send an ambulance to somebody who calls in asking for an ambulance. Strike me down. But Commissioner, I'm sure you agree that if I called in and I wanted a ladder truck at my house for a cat stuck in a tree, I wouldn't have say whether I get that ladder truck. I think we have to stop with this. I think we have to make hard decisions. That's where we absolutely need a partnership with the law community, with the lawyers. We're scared. We are afraid that while we're trying to do the right thing clinically, there are people who will pursue us looking for a mistake. I don't know that you can write a law that allows for innovation. I don't know that you can write a law that allows for intervention. I don't know that. Every law I've seen starts out as a box, and over the years, the box does not open, does not get bigger. The box gets tighter and tighter and tighter. It's so easy to regulate using the law. It's black and white in a lot of cases. It makes it easy. We just, how do we hit the complex issues? Again, the videos that you just saw. Or how do we address the fact that with the baby boomer generation, I'm sure law is the same, where the numbers leaving the profession are not the same as the numbers coming in. I'm insinuating that. I don't know if that's true in the law industry, but every industry that I know of, from pilots to doctors to nurses to medics, the numbers are getting worse, and as the population ages, the demand is getting higher. Also, people are not staying in the hospital. They're out of the hospital. They're sicker out of the hospital. So just when we need a higher level of provider, more providers, we're getting less, and I would offer that the education that they're bringing maybe not to the level that we need. So we need partnerships. When I have a provider, we dialogue about how would you manage these people? I speak to EMS leaders, EMS managers a lot, and they're talking about they have a provider who their term is burnout, and I just kind of challenge them: is there another role that somebody who has 15 or 20 or 25 years of pre-hospital experience, they're burned out? Are they burned out because they don't feel valued? Are they burned out because they just don't run the calls that they ran when they first got in, where they really felt value when they left the scene? Is there another role for them? I think there is another role, and I think part of that is community paramedicine. I think getting out there and doing preventative care is really important, and I think we are losing a whole generation of experienced providers by not including the providers at their end of their career. Did I hit that by accident, or are you giving me a sign that? Just kidding. Sorry, technology. I'm trying to keep my hands off of things, Doug. It's just not working. So we need to use non-traditional resources in non-traditional ways so we can get to the critical patients. Now, critical patients, I had the Air Medical Services come in because I think they have a certain level of expertise on what is a critical patient. And I'll tell you, I've been working for months. I have 2 staff persons. We've been working for months to try to identify that. I want to get our system back to what we were invented for. I want to save the life of critical patients. What's a critical patient? I thought I knew. I thought we could list a critical patient by like maybe 3 or 4 EMD cards, choking and a couple other things. And then the Air Medical Service says, well, I had a 17-year-old that had a testicular torsion. Is that an emergency? It is for him. If he doesn't get treatment in the next narrow window of time, his life is altered. So I need help with that. We need help with that. That's where this the leaders have to begin to focus. I've had the opportunity over this last year to meet with the leaders of a couple organizations, including the AAP and Jerry, and it's really been, at this stage of my career, it's really been neat to have that level of discussion about issues. the complex issues, the difficult issues. But again, without partners in law, we're going to be stymied to, we'll push it to the legislature and expect them to help us answer it. There's other things that we can do, I feel. I'll mention a couple quick things about what we're doing regionally and specifically, and I'll end. We are aggressively using the intermediate level providers. The EMS Act that we operate now under was defined in 2009, and yet still parts of that act have not been implemented in the state. There's parts in the state that still have done no work relative to the intermediate care. I believe for injecting intermediate care, I didn't feel like this 5, 6, 7, 8 years ago, but I now have this epiphany that if we inject intermediate level providers, it's stepping the basic level providers up. It's also allowing the medics to be on reserve for the more critical patients. I think that's important. We have to aggressively build up the QRS services. The QRS services are a quick response service that are in every community, or can be in every community. And they're generally a couple providers from the fire department, or it could be public works or law enforcement. And I want to build them up because I want them to be out there in minutes. There are some patients in the midst of, in our region, 330,000 calls. There are still some patients that every second matters as far as when we get there. Overwhelmingly, it doesn't matter as much, but there are still those patients. I want to build our system based on that. We have a couple subsets of patients that are perceived as the burden. You saw a couple of them. We have providers who are addicted to opiates, substance abuse disorder, I'm sorry, not providers, patients. And our providers go out to those individuals at times more than once a day. How can you continue to feel compassion and empathy when faced with that? Now, it's easy for us to say they should be better, but put yourself in those shoes. You have to feel like you're not making any difference. Long-term care facility patients. Long-term care, do you know that long-term care facility where the older folks reside, call EMS via 911 sometimes for our providers to go out there and lift a patient back into bed because the nurses don't want to risk a back injury. But in that environment, how can we ask these providers to stay empathetic and compassionate? And I think the biggest nugget of all is the behavioral health folks that are out in the street. And I think that's manifested by a lot of things. I think it's manifested by some violence, substance abuse, homelessness, and I think we have to stop tiptoeing around that. I think we have to engage that. But we're not going to fix that by regulation. We're going to fix that by leadership. And we need gray-haired people in the room to help fix this. I'm proud to say that just as of Monday, my organization was awarded $130,000 from the York County Opiate Fund to build out a pilot program where we do field handoffs of opiate overdose patients. I don't know how that's going to work, but we're going to try it. You know, doing the same thing is not going to lead to new answers. We are also going to we've started working with a grant with the long-term care facilities to place a liaison there. And, you know, some of that idea actually came from John Logan, believe it or not. For all his faults, he has a good idea every once in a while. I believe that overwhelmingly the patients that we take from long-term care facilities needn't be transported out of long-term care facilities. I think there's opportunities for us to partner with the long-term care clinical staff and treat those in-house. I understand there's different regulations and different mandates that those nurses have, but think what it does for the care of those elderly people in those nursing homes. When you send a provider out to a nursing home, and they have a person laying flat who's congestive heart failure, fulminating congestive heart failure, on 2 liters of oxygen nasal cannula, we throw our hands up like we're better than them, and we walk up, and yet we make no attempt to help them moving forward. Think if we had a liaison relationship with them, a partner relationship with them, that we could feel comfortable with the relationship to the point where we could educate them as to, maybe a non-rebreather mask and sitting that patient up, maybe CPAP and sitting them up, and they wouldn't even need to be transported is a potential. I'm saying all this that we're doing in a boastful way because I'm very proud of it, but as a potential to not keep treating EMS providers and the public like you saw in these videos. That gal that entered that first bedroom, she was ruined when she walked in that door. She had no business even being in that door. I don't know what her biases were. I don't know what her prejudices are, but I know she looked exhausted, she looked unwell, and I would not doubt for a minute that she has her own mental health battles. What's the answer to that? Not regulation, not law, but innovation. And again, innovation, the barrier between us and successful innovation is the threat of the risk to us. Maybe I feel a little bit more free now because I'm only a handful of years away from retirement. I stuttered there because each day goes by that narrows for me. I wanted to know. So I don't feel the risk of losing my profession, losing my job, but which makes me almost feel a little bit like a coward because I should have taken this risk 10 years ago. I know what I know now. I knew this years ago, and yet I just was part of the machine, part of the, tried to make it good for providers, but I was part of the machine. I need visible leaders in EMS, visible leaders in law to partner with us so that we can make change. I don't care that you think I'm right or wrong. Voice that you think I'm wrong, but let's have a conversation. The EMS system, as I said, looks a lot like it did in the 70s and 80s. And if you look back through innovation, you see that often happens. If you look back through, I would challenge you, look at the history of how CPR was invented, and you will be astounded. You'll be astounded that they used to put people, that CPR was partially invented because of drownings that would occur. They'd put them on a horse and bounce them up and down the beach. But the horse droppings kind of left a bad perspective for beachgoers, so that was bellows. I'll leave that to you. At different orifices, they use bellows. Look it up. And it sounds so ridiculous now. And yet what they were trying to do was make a difference. My son works for Blue Origin down in Cape Canaveral. And, we talk about private rockets and just what's going on with SpaceX and there's a couple other companies. And he keeps saying to me, Dad, you know that we put a person in space in the 60s? Yeah, that was cool. The 60s? How long ago was that? So do we get to a point where we achieve something that we think is a success, and then do we just stay there? The 60s is a long time ago. I know because I was born then. My closing comment is, while the EMS individuals in the room and on Zoom and the law students and lawyers in the room and on Zoom, we come from different worlds. Man, do we in EMS need partnership of visionary, progressive lawyers to help us innovate and do things. We don't want to just do things in good faith, but we want to do things where we're going to make a significant impact and, again, help us overcome those hurdles. And we can't figure it out in our own profession. It's not our expertise. I appreciate you listening to me for a few minutes. Thank you. No question. Is there questions?
There's 6 minutes left, and we're going to extract as much knowledge from you as we can. So please.
Well, that won't take 6 minutes.
So, first, does anyone in the audience or anyone on Zoom have a question for Steve? Because there's a few things I want to follow up with them on.
We do have one from online, from a participant who's a JD and EMT. But going back.
I thought all of those were here.
Is that allowed?
Going back to your comments or your thinking or plans for navigators, The question is, are they enough, is a navigator enough to account for the caller who says her husband just doesn't look right, who's actually experiencing a heart attack? Is it to err on the side of sending the ambulance?
Absolutely. What we have right now, believe it or not, is we have already started 2 years ago holding calls in this region. We didn't bring fanfare to it because we wanted to make sure that we did the right thing. What that means is right now when your ambulance is out of the area, when your ambulance is sent, transport a patient to a hospital, they're now out of your area. If somebody calls them or calls for another ambulance in that same area, we historically have sent the next due. Well, if you can see what happens with that, it's a domino effect where we're pulling this ambulance and this next ambulance. And if it's for non-acute patients, low acuity, I call these patients, all we're doing is we're stealing from the system. And we used to have a lot of elasticity. We don't have elasticity now. So the idea of the nurse triage is we're going to start with the very lowest denominator. And you have to appreciate there's a lot of these that are very obviously, there are people who call 911 who've just fallen. I'm not injured, I don't want it, but I've fallen. I don't have any family. What do you do with that? We send an ambulance. That's what I'm trying to fix. And I didn't comment much on or at all on the fact that I believe strongly a success is in citizen response also. So when you have an elderly person who calls and says, I've fallen, I need help, I think it's neat for us to maybe send out a Medical Reserve Corps member, but also engage the neighbors so that the next time she can call the neighbor instead of calling 911. But absolutely, I'm very sensitive to, I think the easiest part of our system is going to be the high acuity and the very, very low acuity. But those patients in the middle, that'll be the last for us to address. Again, my husband doesn't look well. I've seen some of that, and they really are not well.
And a follow-up to the same participant, she just wanted to let you know the grant projects that you talked about sounded interesting and that she'll be interested in seeing the results. And then another online participant just commented that innovation requires funding. And the partnerships should include our elected officials as well.
The idea of innovation needing funding, and we should have legislators as well involved in the discussion, absolutely agree with that. But I would also say we have to be better at being opportunistic in healthcare. I'm being opportunistic, how? Think of what we just went through in the last 3 or 4 years. What's the federal government do when we have somebody hit the World Trade Center? I make a motion that we send $1 billion to everybody. All right? They start sending money out for preparedness. What do you think they're doing right now after the pandemic? I have hired, in the last year and a half, I've hired 2 public health specialists. When I tell my peers that, their eyes glaze over. They don't understand. Well, I'm absolutely positioning ourselves to fill a gap in that public health environment. So while there are legislative answers to those funding needs, there's also grant answers to those funding needs, and we need to pay attention to that. But absolutely, legislators are a key partner.
So, Steve, I have a question for you. So, I want to ask sort of a regulatory infrastructure question, right? And we only have about 2 minutes left. So, And I guess I'll ask this hypothetically because I don't want to put you on the spot. If this happens and a complaint comes to your desk as the agency that investigates that for this region, an ambulance came, I called an ambulance for my mother. They came and they refused to take her to the hospital. I want you to, bring charges against this ambulance company and investigate it. And I'm irate. Why didn't they take my mom to the hospital? You investigate it. You talk to the crew. You go to the ambulance service. They tell you, well, we did an assessment. This patient had no, acute complaints or medical conditions, essentially needed a ride to the hospital, had no other means to get there. We determined it wasn't an emergency call. We went back in service so we could be available for the next critical call in our community. Great, that's the vision we embrace. What happens when the complaint hits, let's say, the desk of a hypothetical enforcement agency, not yours, of course, and we look at the current laws and regulations? Is there a gap there that would compel you to take some action, or what would the range of options be from an enforcement standpoint if that hits somebody's desk?
The options are limited to what the protocol says. What the protocol defines as a patient, what the law provides as a patient. But I will tell you, the conversation is more complex than that. It's more complex than, have you violated the EMS Act by not taking this person to the hospital if you document it appropriately? I think it's a rare thing, to be honest with you, that I have a patient who wants to go to the hospital is not taken to the hospital. I can't think of those events very often. It's generally the patient is not sure, and EMS gets a refusal by kind of talking them out of going to the hospital, for lack of a better word. I always find it's very beneficial to put them in contact with a patient, and I think that happens all but 100% of the time in our region. And at the end of the day, we follow back up with the patient, hypothetically. We follow up with the patient to just see where they are, and I have had 100% success with them just wanting to be their concerns validated. The average EMS service manager is capable to do that, and I have not had any conflict relative to that, short of, but they billed me. That's where a whole new discussion comes in. So my conversation with the EMS service managers is, you got to think through this from a public relations perspective also. I'm not asking you to waive any bill for service, but what's the bill worth to you? And I kind of let them handle that locally. I did not answer your question.
Oh, you did. Yeah. It was an answer to my question. But, no, thank you. But it was a good answer. So, ladies and gentlemen, please join me in thanking Steve Lyle for sharing his incredible vision. And I hope everybody noticed when he took personal accountability, right, which was very modest of you to do that, to say, look, I knew this stuff. We knew this 10 years ago, and, we all played a part in just sort of perpetuating the system. I'm guilty of that too, right? But for a person who's been in EMS as long as this guy to stand up and embrace evidence-based practices and progressive thinking on how we manage an EMS system speaks volumes about this guy's leadership. So, sir, thank you so much for that. So now, because Steve was, inadvertently clicking ahead on slides, we did not lose our 15-minute break just because of his premature clicking, I guess. But we do have a 15-minute break, and we'll see you back here at 10:30. Thank you. Okay, folks, if everybody wants to start making their way back to their seats, we're going to get the next panel going. And while our panelists are getting set, I want to make a couple of other brief introductions from some of you're going to meet a couple of the other people from our firm, from Page, Wolfberg Wirth, who will be speakers, Christy and Matt, and they'll get introduced when they come up to speak. But I also want to introduce my partner, Ryan Stark, who was last year's keynote speaker, and our new associate, Scott Jochen, both of whom are Widener Commonwealth Law graduates, so we're happy to have them here with us from PWW. Okay. Yeah. All right, ladies and gentlemen, this auspicious collection of talent we have in front of us here, I'm going to name everybody we have here and then ask them to briefly introduce themselves. First, I have Heather Schrar, who is the Executive Director of the Ambulance Association of Pennsylvania, who's going to provide us with a legislative update of initiatives that the Ambulance Association is working on. Also, we have next to her Sean Harris, who is the Republican Executive Director of the House Veterans Affairs and Emergency Preparedness Committee. To his left is Jerry Ozog, who is the Executive Director of the Pennsylvania Fire and Emergency Services Institute. We have Nathan Silcox, who is the Republican Executive Director of the Senate Veterans Affairs and Emergency Preparedness Committee. To his left, we have Mike Hillman, who is the Democratic Executive Director of the House Emergency Preparedness and Veterans Affairs Committee. And then last but certainly not least, we have Jeff Kavanaugh, the Democratic Executive Director of the Senate Emergency Preparedness and Veterans Affairs Committee. So what we have here, folks, are on both the Senate and the House side, the Democratic and Republican directors of the key committees in the Pennsylvania legislature that address EMS legislative issues. So these are literally the folks that make the legislation happen, and we have bipartisan representation here today. So we are so grateful for all of you in being here with us and sharing your time and your expertise with us. Can we just go down the line and ask each panelist to further introduce themselves? If there's anything else they want to say about themselves or their background? Heather?
Not really.
Okay, thanks.
I'm Heather Scher. I'm the Executive Director of the Ambulance Association, and I've been in this position for almost 18 years. And I will get into our legislative agenda, but when I was going through our legislative agenda, we've actually made quite a bit of progress this year after, in my mind, I was thinking that we didn't. So this has actually been a pretty good year. I stood here last year and talked about $85 million that EMS had gotten, and we have some exciting news now, but I will say that.
And just to add some commentary, in the decades that I've been working with and observing the Ambulance Association of Pennsylvania, I can't think of a more effective leadership team than what's been in place under Heather's guidance and the officers and leaders of the Ambulance Association, and the success that they've had on behalf of the whole industry and profession in Pennsylvania has been unlike anything I've seen in the 45 years I've been paying attention to EMS stuff in Pennsylvania. So can't wait to hear those updates. Sean, brief intro?
Sure, I'll make it nice and sweet and quick. I've been with the House since 2003 of January, and I'm in my 21st year, in my 16th, going into my 17th on the committee.
Thank you. Jerry.
Hello, my name is Jerry Ozog. I'm the Executive Director of the Pennsylvania Fire and Emergency Services Institute. We're a statewide advocacy and education organization. We're a 501c3 nonprofit, and I want to make sure that I recognize one of our board members that is here also, and that's former Commissioner Ed Mann. So thanks to Ed's here to be part of this. And I think he's attending because he's part of FAME EMS too, I believe. So he is well integrated in this. So I'm also active in emergency services in Cumberland County. I served as the deputy chief in the Hampton Township Volunteer Fire Company. So I still see what's going on in the field, and I do travel across Pennsylvania quite frequently, meeting with county-wide groups, stations, different town hall events, to kind of really find out what's happening in the communities, that we can come back to Harrisburg and kind of make sure that we work to have some positive movement to improve our operations.
Quick color commentary also. Jerry's leadership from the Fire and Emergency Services Institute has been instrumental in the legislative successes that we've had on in the EMS side. I don't think too much would happen if the fire service opposed what was being introduced. And I've never really seen a more effective relationship between fire and EMS sides of our legislative advocacy as I have with these two advocates sitting here. So I think that had to be said. So Jerry, thank you. Nathan.
Thanks, Doug, and thanks for having me again. Corinna, thanks for inviting me. Since 2001, I've served here in the Senate. Since 2015, 16 legislative session, I've served as the executive director here at the Senate Veterans Affairs Emergency Preparedness Committee. It's been a great joy working for first responders, and particularly here at EMS. Thanks for having me back on this front. Locally, I'm a township commissioner, so I've got that aspect from the local. Jerry's one of our firefighters in Hampton Township, and so being able to see it from that angle, working through EMS issues as a township, working through EMS issues through our Capital Region Council of Government, through that layer, and obviously here in the Senate. So a couple different layers to be able to see it from and trying to address some of the major issues facing the EMS world.
Thank you. Mike, go ahead.
Good morning, everyone. My name is Mike Hillman. I've been with the Pennsylvania House for 17 years, and I've been with the committee for 5 years. It's great to be here and see some familiar faces from the work groups that we've had through the years. Actually, when I started with the committee, it was right in the midst of SR6, so I got thrown right into it, and glad to be here today and to meet some new folks as well. So thank you all for having me.
Thank you. And finally, Jeff.
Jeff Kavanaugh. I'm
been with the Senate since 2006. I'm Senator Katie Moot's Deputy Chief of Staff. She's the Democratic Chair of the Senate Veterans Affairs and Emergency Preparedness Committee. Glad to be here. Thanks to everyone here for your community service. You guys are really doing a great job, and we hope we can do more of this session to make your jobs easier.
Thank you. Heather, podium is yours. Or the seat. You can stay seated, that's fine.
I'll sit. All right, so last year I mentioned the $85 million that the legislature did provide to EMS. This year, the legislative session, no offense, was a little slow to get things started, and then all of a sudden, wham. So our legislative agenda, our board members actually have a strategic planning session every January, and they talk about the legislative priorities and other priorities. So in January of this year, our legislative agenda was released. And I have to say, listening to Steve when he was talking about how EMS providers are responsive, they respond, that is what they're used to. I do have to say the AAP board members are actually proactive, and they try to think about where they want to go and where they want to see. So those innovations that Steve talked about, I think my board would be very supportive of if they had the chance to discuss those. So the first item on our legislative agenda was medical assistance, and we wanted to change the reimbursement for the mileage because in 2014, the DHS at the time was OMAP, the Office of Medical Assistance Programs, decided that they were going to pay for all loaded miles minus the first 20. And so that initially wiped out the mileage reimbursement for EMS. So we fought long and hard for 9 years, and I'm very happy to say that the legislature passed House Bill 1351. Couldn't remember off the top of my head. It's Act 15 of 2023. And that actually removes that mileage stipulation, and it also takes the reimbursement up to the higher of Medicare or medical assistance. So that was huge for the EMS community. And so the AAP really worked with the legislators to make this happen. There were a couple of bills, and these are the kind of the things that you don't see behind the scenes. Representative Borowski, who was a Democratic freshman, she actually introduced a piece of legislation that would have removed the mileage reimbursement. And when it went over to the Senate, it became the fiscal code, came back to the House, there were some other issues. Then Senator Brooks with Senate Bill 555 also tried to remove the mileage minus the first 5, and that didn't happen. And then House Bill 1351, it was a Department of Human Services bill that they were actually able to attach this to. So that has now passed. It takes effect in January of 2024, which is a wonderful thing. So that was the first item on our legislative agenda, which we're very thrilled about. We also have some regulatory fixes under Title 55 that need to be done yet, so that is on our radar. Raising the Medicaid rate comparable to the Medicare rate, that was actually done, so that's a wonderful thing. Moving to sustainable funding. When you look at EMS, it's reimbursement for the service you provide, but there's also a cost to readiness, and we have used this as a buzz term for a long time. It is difficult to maintain fiscal unviability, if that's a word, and EMS is in that situation now where they're not making ends meet. So we need a non-optional model for that sustainable funding. We will always support funding that is provided directly to transporting EMS agencies. One of the other items on the list is that EMS, according to Act 37, which Steve had mentioned earlier, it says that EMS is an essential service. It should be promoted, acknowledged, and supported as such. So what does that mean? That means we need that sustainability. We need the fiscal viability. Recruitment, retention, and workforce development was also high on the legislative agenda. We have been working with a work group that has all of the regional councils represented. There are representatives from EMS agencies from across the state. The Bureau of EMS has also participated, and everybody at this table has also been invited and participates. We are investigating what needs to be done to get workforce into this state and how we can pay them correctly, and all this kind of ties in together. We are also investigating funding through the Department of Labor and Industry, and there will be more come out about that. We are investigating a statewide fee schedule, and that is because we've got the Ground Ambulance Patient Billing Committee looking at how they can prevent balanced billing when it comes to EMS at the federal level. I won't get into my personal opinion on that. But there are things that we could do in this state, and I think a statewide fee schedule, my board also believes that a statewide fee schedule might be able to help that. Also, elimination of the co-pays and deductibles for emergency services is another option. Under the insurance reimbursement, requiring the commercial insurers to pay at the base rate, AO425, AO426, et cetera, for claims related to treat no transport is also on the list. The Senate passed earlier this year SR 120, which asks the Legislative Budget and Finance Committee to look at how EMS is not paid when it comes to treat no transport and for opioid overdoses. So we're actually working with the Legislative Budget and Finance Committee on that as well. So that is our legislative agenda. So we've actually made some really good progress. I was kind of a little frustrated earlier in the year because it didn't feel like anything was happening, and then all of a sudden, wham. Am I taking up too much time? No. Because I could talk for a long time. We have requested just this week an EMS commission similar to the Maine Blue Ribbon Commission that would actually look at EMS specifically. We've actually started the work with this workforce task force. And so there will be more come out about that. We actually are working with Page, Wolfberg Wirth. We filed an amicus brief. They actually filed the amicus brief on our behalf for the VA rule at the federal level. We are also partner with the Pennsylvania Fire and Emergency Services Institute. We are supporting Senate Bill 501. We do work with the Pennsylvania Emergency Health Services Council. Jerry also worked with the Firefighters Association and the Pennsylvania Career Fire Chiefs Association on a joint letter. We have a foundation. We had $10 million that was given to us through Highmark, and I did talk about this last year. We were able to distribute that to EMS agencies across the state. And then we also, this last year, with the money we raised through our weekend of recognition and remembrance, we gave 9 scholarships in the amount of $3,000. So we were able to give $27,000 away. And then lastly, and I will shut up, we are working with Page, Wolfberg Wirth also on the protocols. Steve had mentioned the legal aspects of the term abandonment, which the AAP was incredibly concerned about. And there are some other items. So we are actually working with the Bureau of EMS on those legal issues that Page, Wolfberg Wirth did review. Shut up on that end.
Thank you. Are there questions for Heather specifically on any of the things that she mentioned in her presentation? So real quickly, I want to just mention that yesterday the website ems1.com, which is National EMS Publication, published a new article that we just contributed called, well, I forget what exactly it's called, Stop the Nonsense, Patient Abandonment, or something like that, because there's a lot of sins being committed in the name of patient abandonment. A lot of the innovations that Steve talked about earlier, if we don't transport everybody, it's abandonment, and this silliness we saw in the Pennsylvania EMS protocols. So it prompted me to write this article, and just one quick quote from that article. Patient abandonment in EMS is a bucket of warm hogwash. And I'll let you read the rest of it I don't want to spoil it. So any questions or comments? Anything online, Corinna? Thank you. Okay, Jerry, would you like to give an update from the status of the Pennsylvania Fire and Emergency Services Institute?
Absolutely. Similar process we have with our legislative priorities in that we reach out to our statewide advisory board, we reach out to our board members, and one of the unique things that I feel very proud about that was what we call our Joint Law and Legislative Committee. And what that came together is a vision from one of the members of the Career Fire Chiefs Association is, let's meet on a quarterly basis or a more frequent basis the 4 main fire service organizations in Pennsylvania. The Firefighters Association of the state of Pennsylvania, the Pennsylvania Career Fire Chiefs Association, the Professional Firefighters Association, and our organization, where we could coordinate and develop our legislative priorities. And for this session, the main focus that we have been focusing on, aside from supporting all the EMS legislation and all the things that you've already heard, is the reform of the Volunteer Fire Relief Association. Now, that may not specifically address many EMS issues in here, but it'll be a big deal for the fire service organizations in Pennsylvania, and we'll be seeing some continued movement through that. But again, as Heather noted, there's a lot of different things that happen behind the scenes, and I say at every one of these, and I think I've been a speaker at these since the beginning, 5 years ago, is the ability to talk and tell your story, and we've been able to do that. Working with the gentleman to my left in regards to specifically Senate Bill 501, which was the countywide EMS authorities legislation that passed out of the committee, and I'll let Nate and the rest of the team talk about that today. There has been much discussions, and that's been going on for maybe 3 or 4 years. It was in last session, but we really feel positive about that in what we believe in our organization. So with that, I'm going to be able to answer a few questions as we move on, but we'll let the others speak as we can.
Thank you, Jerry. Now I want to go down the line, and I'll probably show my ignorance of legislative protocol. So there's no particular order or rhyme or reason, but I'd like our other panelists to give an overview of things that they might be working on that this group might be interested in, and any other thoughts really that they have. Jeff, I'm going to start with you, just because you've been last down the line for our introductions.
By design.
And wait, you did specifically say, please don't call on me first.
Yeah,
but
don't come to me first. Senator Booth has been really advocating for the 911 reauthorization and the fee increase, which will help you guys do your job. We're hoping we get that done in December here. There's bills out there that we're supportive of for PTSI coverage for EMS, first responders. There's lots of good ideas out there. We know your jobs are hard, and we know that the state could do more to support you. I know that there's some frustration from the senator's perspective, at least, that as Heather had said, EMS is an essential service. We should treat it as such. Our local EMS companies, fire companies, rely on grants, things like that. If we can figure out how to do something better in that space, that'd be ideal. But
thank you. Does anybody have any questions right now for Jeff? We'll have more questions for the panelists generally, but anything for Jeff? Thank you. Let's stay on the Senate side. Nathan, you want to give us your perspectives?
Sure. Look, again, thank you for having us. Thank you for putting this together. We've had a number of conversations over the last couple of years, and even this forum has helped lead to legislation such as the EMS Compact, which is now law. And let me give credit here to both Jerry and Heather here for leadership in their organizations. Jerry's been talking about SR6 and giving updates on the SR6 since the final report in 2018. So it's been a regular meeting of those groups, and during the last session, Heather and the Ambulance Association, the EMS organizations have gotten together to prioritize what's needed on their front. That's been effective. Last session led to several new laws, just not the EMS Compact. The ambulance staffing waiver got done. Representative Marty Kauser was able to get through a bump in the reimbursement rate as well. So a number of good things happened towards the end of last session. You just heard Heather talk about the House Bill 1351 getting done, a huge shot of $126 million into the EMS world. So that's helpful. And you just talked about Senate Bill 501. We've talked about the countywide authority legislation. Last year at this forum, there was a presentation giving an overview of what the authorities legislation was, and how it could help the world of EMS. So we're pleased that Senate Bill 501 was moved out of our committee here a couple weeks ago. I'm hopeful, whether it's in the December time period or January time period, we could get a full Senate vote on that legislation. Again, it provides another tool in the toolbox here for the EMS world. It's not mandatory, it's not a mandate. It's not a mandate on counties. they have almost first dibs if they would like to try to go down that route, but it's also not mandatory on the municipalities within that county. It's optional for them, and it could also be done ground up on that front. So looking forward to getting passage of that legislation, having the conversations to get that one done. But again, these continued conversations are very helpful for us to lead to results.
Thank you. So Nathan, a couple times you mentioned the EMS Compact, and I just want to make sure folks know exactly what that is. Would you like to just give a quick, or would you like me to do that?
You're just as good as well, but I mean, I believe we're at about 20, just over 20 some states. I don't know if any other states have joined since then, but it gives a greater opportunity to go from one state to another state, going through a seamless transition from one state to another state, whether it be in an emergency situation or a transfer of licenses. Certainly helps our military folks that have that EMS aspect as well, but you're certainly welcome to.
No, that's a great summary, and I just want to make sure folks are aware that Pennsylvania is one of what is still a slight minority of states that have passed the Interstate EMS Compact, and medical practice has done that, physicians, nurses, other occupations and professions. And this is a big thing, right? And what it, again, as Nathan said, it allows EMS practitioners who are certified or licensed in a compact member state to essentially practice EMS in other states, not as a freelancer, but drive around with your trauma kit and your blue light, but for an EMS agency. And so that was a significant legislative achievement, and I would urge folks to visit emscompact.gov. Where you can see the states that are participating in the EMS Compact. Those are public meetings. Anybody can attend those. They're all online, but I would urge folks to get acquainted with that. We represent at PWW a number of professional licensing interstate compacts in healthcare, and the EMS one is really one of the least bureaucratic. In most of the compacts, you have to file for a privilege to practice in other states. In the EMS Compact, by virtue of being licensed or certified in one of the member states, the privilege to practice automatically applies in other compact member states. So it's a very low bureaucratic, low barriers and obstacles to interstate practice, really one of the most streamlined interstate licensing compacts that I think exists, maybe except for driver's licensing, because you don't have to stop at the border and show your driver's license when you cross into another state. But so it's something that I think was a big legislative accomplishment among all the others that are so amazing that we've heard about. So thank you for mentioning that. Let's transition over to the House side. Kanini Meany, Mike, would you like to start us off?
Sure thing.
Thank you.
Thank you, Heather, for summarizing a lot of that. I know Nathan and I were talking recently about our successes this year, and I think in the first 20 laws that were signed in 2023, 4 of them came through our committee. That's 20% rate there. That's pretty good. So that doesn't mean the job's done. We've been pretty heavily focused on reauthorizing the 911 law with a revenue level that's going to support the rollout and the success of the next generation 911 system, so that you all have the resources you need to be able to respond in a timely and effective manner. Hopefully we can get that done here by the end of the year with the Senate's help. Of course, we've also been looking at, going into the new year, we're going to be taking a look for sure at the Public Safety Authority model. And I think the big lift for next year is going to be the reauthorization of the fire company and EMS grant program. The opportunity to reauthorize that is also the opportunity to think about maybe some other ways that we can push that money out in a more effective way. So excited to start that conversation. We've also seen a bit of an influx of revenue over the last few years through things such as expanded fireworks tax that has given us some additional resources, and I think that could help going forward into the grant program reauthorization. There's some other ideas for new revenue out there as well that I think will be some interesting conversations. We've also been, as Jeff mentioned, looking at workers' comp coverage for first responders who are dealing with post-traumatic stress injuries, helping get them back on the job so that they can be effective in what they need to do. It's more on the fire side, but I think it'll help you all out as well. We've been working together on some urban search and rescue analysis of what that system needs to look like going forward. So I think we've done a lot of good work so far. We've got a lot of irons in the fire, and we've had some good successes, so I think we can continue to build on that momentum.
Thank you, Mike. Sean, last but not least, House Republican.
No, I'll keep this short. I like to get the Q&A because I know you don't need us to stand up here, certainly me, with diarrhea in the mouth to preach at you, so I'm not going to do that. But I will say, one of the things we need to do is to continue on the SR6 initiatives, as well as the work group that's going on the EMS side. So, in saying that, funding, staffing, and training, those are your three pillars of your system, and they're crumbling right now, and it's going to crash if we don't do anything about that. So we need to focus on issues that we can plug those cracks to keep that from happening. And my final point is, unfortunately for EMS, Medicare, Medicaid, commercial insurers, and the underinsured and everything else. That's your biggest problem right there, because that's your funding. And without the funding, you can't do everything else. So everything you heard up here is geared towards addressing those three pillars in the system. Thank you.
Outstanding, thank you. So let me, I want one quick follow-up because, Mike, you were talking about the 911 reauthorization, and I'm going just off of memory here, but I haven't reviewed the legislation recently. But that's the law that, among other things, allows for a per-line assessment of telephone service imposed by the carriers that then goes to support 911 systems. Is that correct?
That's correct. I think that rate was set at $1.65 in 2015. Just looking simply at the inflation index since then shows us that it should be about $2.10 at this point. So there was a proposal from the governor that Chairman Solomon introduced that was $1.97 plus an annual escalator based on inflation. Our Senate friends weren't willing to get there with us, and that's okay. That's part of the process. So we're continuing to talk through that. I know the county commissioners have proposed a $2.30 fee with an annual escalator. So we're going to see where that comes down. That's kind of probably the major sticking point. I think we would agree in getting that law done. But there's a lot of other substantive policy changes that have to happen as well. So we've recently introduced another bill in the House that addresses some of that in our conversations with PEMA, and I think some of you probably sit on that advisory board that helped develop those recommendations. So we're looking forward to engaging on that front as well.
And that's a critical component. You mentioned the county commissioners. I mean, they're the ones that usually bear the burden of funding and operating the PSAPs, the public safety answering points, the 911 centers. But again, back to Steve's sort of unifying talk here, right? Talked about clinical decision making at the dispatch side, right? And how important that is. Instead of just you call, we haul, dial 911, everybody gets an ambulance, like Oprah, you get an ambulance and you get an ambulance. But this idea of clinical determinations for proper deployment, right, starts when the phone rings. And if we don't have the resources to support 911 systems so that the dispatchers, the EMDs, the emergency medical dispatchers, the telecommunicators can properly make those determinations at the time of the call, that whole vision, most of that vision cannot be realized. So I just want to, these guys deal with this stuff every day and they talk about, this is important. It is so critical, right, to make sure that all of the other visions we want to realize for the system, right, these folks are dealing with that every day. And you just heard how facile they are with these issues, right? How understanding they are of what the key issues are facing the industry, and that's comforting to see and to hear that they're so well versed on these things, and so bipartisan. I was just heartened watching you guys all talk to each other in the hallway, right? Just how cordially you treat each other. It's such a nice thing to see and to hear in such a polarized society, but to work together for the benefit of EMS, fire, and public safety, it's incredible. It's so great to see. So I think we all owe you all a great debt of gratitude for the dedication and the professionalism you all bring to that task. So thank you. Let me turn it open to the floor for questions. We've got the people here, folks. So, Commissioner.
To the legislative panel, who's in opposition to the EMS Authorities Act?
Good question.
So right now we've got a great deal of support overall. So from the municipal end, you've got the county commissioners are supportive, the boroughs association, the first class townships, and municipal authorities association, as well as the Pennsylvania Municipal League. Township Supervisors Association hasn't signed aboard that yet, so there's one from that angle. In terms of the firefighters, Jerry named off the main groups, PFESI, that Jerry represents is supportive. Ambulance Association is supportive. The career chiefs are supportive. The Firefighters Association are supportive. The Professional Firefighters Association are the ones that are not on board yet. So we're working through trying to get those two groups.
Okay, so a follow-up. What's their opposition? Why are they opposed?
Sure. I think one of the things we need to be careful with, and I think it's been a great strategy this session to separate the two, fire and EMS. But of course, if you move one, the other one takes a look at it and says, well, you're coming at us next. And I think in our discussions with our friends who are organized labor firefighters, they have concerns about how their contracts might be affected. They want to make sure that they're able to negotiate with the proper parties. And I think that that's something that's solvable and we can work through with them. So we're continuing to engage in those conversations.
So last session's legislation was countywide authorities overall, both fire and EMS. This session's legislation has been separated, so Senate Bill 501 is strictly EMS, but nonetheless, like Mike said, the Professional Firefighters Association has expressed its concern over collective bargaining and how that might affect.
They also raised an issue, if I may, about just making sure that that when these departments are put together under one umbrella, that the technology interoperability can work, and that maybe someone doesn't need to downgrade their technology to match the system. So just some of those nuts and bolts logistics to work through to get everybody together on that.
And Township Supervisors Association, right now the bill is configured, and it can certainly be changed to address any of the concerns. Would permit, a county-wide authority, or it could permit, I believe, two authorities within that maybe aren't entire county-wide. Township Supervisors Association, I believe, expressed that, why not three or more in that vein. So, look, we'll continue to have those discussions. Again, this is the first session that's actually been moved out of committee, and appreciate everybody's dialogue on that front.
So will it have any impact on the authorities that have already been created? Because there have been recently some ambulance authorities that have already been created.
Right, there have been 8 is my understanding, and I believe Lancaster is now number 9 in the mix. With what they've done, I think 8 are involved in the Lancaster mix. This will just essentially codify that ability to do so. I believe that they would be.
Gary, would you like to jump in at all? Gary Waters is the executive director of the AMED Authority, which is a municipal ambulance authority.
Yeah, currently Senate Bill 501 grandfathers the existing authorities from any of the restrictions that are being placed upon the new authorities that are within there.
Anything else about the wisdom of organizing as an authority? Yeah, Gary's comment was that there is a grandfathering clause in for existing ambulance authorities to operate as they have been originally chartered. But any other points you'd like to add about municipal authorities, since you are one?
Quite frankly, yeah, I mean, I got a kind of a jaded viewpoint from it. It's probably one of the, it's probably one of the better sustainable models because it allows you to have the ability to operate as a quasi-governmental agency. It brings transparency to the organizations, and but the best part of it is, and what is really needed in this legislation is what is defined as service, because authorities can implement fees and charges for the services they provide. And we've talked about the fee for readiness and about the fact that there's got to be a fee for readiness. So one of the things that we've proposed as amendment to it is that service includes the availability of the service. Wow, that changed.
Voice of God, Gary.
So the point is that charging for the availability of having an ambulance sitting there staffed 24 hours a day is a legitimate fee that can be assessed by the ambulance service. And really, if you look at any legislation that's been out there, it is the only one that really proposes a good model to pay for that fee that is not obligatory upon anybody in this Commonwealth. The municipalities can either do it or they can't. They can opt in to do it or not.
Well, thank you, and thank you for letting me put you on the spot as I think the only municipal authority director sitting in the room, because that's a big issue, and there's so many efficiencies that can be achieved with that model that it's nice to see, especially the compromise and the give and take that's happening too, to make sure these stakeholders get on board. Commissioner, those were all great questions as well, so thank you for asking those. Do we have other questions for our panel about any subject? Yes, sir?
So while the authority model seems to have the biggest, sorry. Okay.
This way our Zoom people can.
Understood. So while the authority model has the most energy right now, and ultimately it means that ambulances can get together and the burden then would fall to the authorities to raise the funding as opposed to a township that might not be willing to do so. Ultimately, both of those get me to the same point where I'm still paying more for my ambulance service. You've pushed that burden back to the taxpayer. When I believe the burden of our healthcare delivery system should be borne by insurers. A significant part of our billing component resides in the hands of Medicare, Medicaid, and you've done tremendous with Medicaid as a state regulatory agency. But the ability to write policy for a private insurer belongs in your hands and that of the insurance department. And so we've had current problems. So the questions of direct pay and the looming dangers of surprise billing or balance billing, whatever we're going to call it this week.
Surprise lack of insurance coverage.
And it is for us it's a joke, but I will tell you that the insurers are the ones that are not laughing, and those are the ones that are actively pursuing pulling every dollar back. How do you take what is a EMS problem and really turn it back on itself, that if we are healthcare providers and we are a medical division, then we should be compensated as such. So how do you push the insurance agencies to pick up the burden, the balance of it, before you push authorities and push us back to, well, the taxpayers will pick up the bill? It's okay, but I don't pay the police departments. I pay them in my taxes, but I also don't pay a premium to a Simply Safe or to another allied security to drive around my house. But fundamentally, EMS needs to be delivered and funded because I do pay health insurance, and I believe, and all of my patients and all of the people who call our offices believe that an ambulance is part of their health care package. Yet I am consistently reminded by those who make the payments that they are really trying not to be. How do we get the insurers on board?
Well, that's not too much of a hot tamale or loaded question. So what's the answer to taking on the insurance industry, I think, is the summary of the question.
That's a major caveat. No disrespect to my colleagues on this issue, but it's a natural progression. When one entity picks up the tab, the other one is going to back down when they're not required to provide. So if I'm an insurance carrier and there is a funding mechanism that's being established and growing that's supporting a system that everybody says is needed and essential, but I'm not required to pay a certain amount, I'm going to back down. And that's a natural progression. It happens in government. If the state government picks up the tab on something, the federal government's going to step back and say, we don't have to do it. We don't have to do it. You're already doing it, and they're going to send their resources elsewhere. That's something that has to be seriously considered, because if you go forward with the authority model, there's no corresponding apparatus to hold them accountable. And it goes back to the point you said. Those out there are under the impression that their services that are being provided to them, whether it's their family doctor, the dentist, or EMS, or a podiatrist, it doesn't matter. It's being paid by insurance. And that is a reality that has to be faced. And I think it's important to also make a distinction between what an authority is today in the current statute versus what some folks out there think it should be. Because under an authority, you have the ability to establish such an entity that is a quasi-government entity that has all governmental powers and immunity and can bond, borrow money, and come after you if you don't make the payments. Whereas you're trying to take a system of independently chartered nonprofit entities and pulling them into this animal, whatever that animal is. And so getting from A to Z, it's got to work. So it's great to try to address the problem in that way, but the devil's in the details. And those are the things that have to be hammered out going forward.
Thank you, Sean. Would any of our other panelists like to be heard?
Sure. Look, countywide authorities is the best solution out there until there's a better one. So if there's a better solution, I'd love to hear it. If it's the insurance industry on that front, fantastic. Love to see that. But that's out of my domain in terms of my committee. So as we talk about this issue and talk about this issue and talk about the issue in terms of ambulance providers closing and this one closing, that one closing, this provides the ability to address the situation, and that's what I'm working towards as a solution for Mara.
Thank you.
I think Sean and I have gotten together and butted heads with the insurance folks several times through the years, and I think that's not going to stop because that is really that's a friction point here in this conversation. I think it would be fair to say that this cost is going to be borne by someone. It's a matter of how we slice that up. So whether it's the taxpayers, the burden's diluted through the taxpayer model, or it's diluted through the insurance premium model, you're going to see someone paying somewhere. The thing that I think I could probably speak for Senator Muth as well as Chairman Solomon. The thing that we don't want to do is we don't want to put that as a surprise onto the backs of someone, because as we've discussed, a lot of the folks out there don't know that they're not covered. So to then hit them with $1,000, $2,000, $3,000 bill on top of what they thought was going to be covered, that's just not a sustainable way to go about it. So I'm encouraged and heartened by the discussions about the fee schedule that we're talking about. I think that can help get us to a point where we can resolve a lot of things, including the direct pay issue. I think that's really a good blueprint for that. So I think that we have a way out of this. I think we need to be realistic about there are costs. They're going to be borne by somebody. How can we best distribute that so that the right people are paying the right amount? And of course, that's open to interpretation among all of us and the folks we work for. So
that's a very good point right there, because when you talk about who's going to be responsible for the payment, well, if you want to create a countywide authority, well, the current statute says that the local governments are responsible to ensure fire and EMS services are provided within their district, in their jurisdiction. So you would need to remove that, because now you're placing the burden on the county and removing it from the local governments. And do we want to do that? And those are the issues we have to work out.
Was a county commissioner from the West Shore shaking his head no? Or a township commissioner?
Yeah. Look, that obligation is still there, and if they would, as long as they're providing for it, if it's under the authority model, then they're still providing for it. If they opt out of that, then they're still required to provide for it. So I don't necessarily think that that's needed.
So I know we're out of time. Christy, I ask your indulgence for 1 second. Our next presenter will be up in a second. But something that was mentioned here that I think I just would like a 30-second maybe answer from a couple of panelists here. EMS as an essential service was mentioned. Now, we could pass a piece of legislation that says EMS is an essential service, and you get a little sticker to wear on your lapel. If that doesn't come with certain funding and certain obligations and certain meanings, what is EMS as an essential service, essentially? Anyone? No? Nobody's touching it?
Let me just, one important facet is here, we're the legislative folks here on this end. We passed a number of laws here in the last since 2018. And we've addressed a number of them, maybe not to the full extent that we all like to, but we've taken some significant steps. And I'm pleased earlier it was mentioned, we have a new EMS director in the Bureau of Health. A number of these laws, do need to get implemented. And we're going to, in terms of EMS is important, the legislature, we've certainly taken those steps to address that from our end, and we'll continue to work on that. But we also do need that partner in the Department of Health, the Bureau of EMS, to implement a number of these things, whether it's the mental wellness and stress management legislation that was passed back in 2020. We mentioned here earlier, Act 104 of 2022 repurposed a number of the fireworks dollars, new tuition assistance program, a pilot program between higher education and secondary education. We need to get those things implemented and in the works. It was mentioned earlier, the fire and EMS grants. We did up the amount that comes out. That period is just was started in September, and so those funding will be awarded too soon. So $15,000 now for EMS world, $20,000 for the fire world, and those are all positive steps that we can all take credit for and then keep moving the ball forward.
Fair enough, and we appreciate the reminder that there are indeed 3 branches of government that have to make this stuff work. So thank you for that. Ladies and gentlemen, please join us in recognizing our panelists for their time and their expertise and sharing that with us here today. Thank you all so much. So we're going to jump right into the next session. Our next presenter is Christy Malott, who is of counsel with Page Wolfberg Wirth. Christy joined PWW in 2000, which is actually the year we were formed, so she has been with us almost since the beginning, and she is going to talk about EMS, human capital, and the law. It's our HR update and what's happening in the world of EMS. So, Christy, it's all yours. Thank you.
How do we get that? I'm getting there.
All right, Brian's got you covered.
Oh, it's not on yet?
Well, it's coming. I mean, they can see it on Zoom and they can see it on the TV, so they're good to go.
That's the guy who wrote the bill. All right, so apparently I'm technologically challenged. Why is this clicker not working?
I could write it. That was a joke.
Did you? Yeah. All right. All right, so what we're going to discuss today are the HR updates, basically employment law things that have happened recently that every EMS manager in the audience should take note of, as well as what I would consider a hot topic that I want to make sure that every EMS manager in the office is aware of what the laws are. So we're going to start with the Supreme Court case that changed the religious accommodation standard. Then we're going to go through a few Department of Labor updates like the Pump Act, the proposed overtime changes, the change in the OSHA reporting requirements. We're going to touch on the Pregnant Workers Fairness Act, the expiration of the vaccine mandates, volunteer staffing issues, and a new Department of Justice initiative on communications in healthcare. So let's start with the Supreme Court case, Groff versus DeJoy. It was a June 29th, 2023 case, and it did away with the former de minimis standard for religious accommodation. So the facts of the case are that Mr. Groff worked for the U.S. Postal Service in Lancaster County, probably not 10, 15 minutes from here. So he started out working, he was very religious and didn't want to work on Sundays. And at the beginning, you know, the U.S. Postal Service, none of us got mail on Sundays, it wasn't a big deal. But then Amazon came along and wanted the Postal Service employees to work on Sunday, and Mr. Groff was forced to work on Sunday. And the Postal Service initially tried to work his schedule so that he wasn't working on Sundays, but as you might imagine, when Mr. DeGroff wasn't working on Sundays, everyone in his small office was picking up his shifts for him, which went over about like a leaded balloon. So the U.S. Postal Service decided it was an undue hardship to try to continue doing this for Mr. DeGroff, and they stopped allowing him not to work Sundays, forced him to work Sundays. So this case had a bunch of different good quotes that I would want to make sure all of you are aware of. Showing more than a de minimis cost does not suffice to establish undue hardship under Title VII, and employers have an undue hardship when the burden is substantial in the context of an employer's business. And they determined that simply because the Postal Service had to continue paying overtime for the rest of its employees, you know, that kind of a cost in and of itself isn't enough to be substantial of a burden. So here's some other good quotes from it. It would not be enough for an employer to conclude that forcing other employees to work overtime would constitute an undue hardship. Consideration of other options such as voluntary shift swapping would also be necessary. And we think it's enough to say that employer must show that the burden in granting an accommodation would result in substantial increased costs in relation to the conduct of its particular business. So the takeaways that all of you EMS managers need to have is when people come to you with accommodation requests, such as religious accommodation requests, don't just flippantly dismiss them and say, oh my gosh, I'm going to have to pay overtime for the rest of my staff. I can't do that. No, you've got to actually do the numbers, crunch the numbers, because simply having an increased cost in and of itself is no longer okay. You have to make sure that it really is substantial and involve your legal counsel in what you think may actually be a substantial undue hardship. Don't just flippantly deny the request when it comes in. and exercise caution, not just with a religious accommodation request, but with all types of accommodation requests, because I think the other takeaway is the Supreme Court sent a clear message that they want people, employers, to make sure that they're evaluating this thoroughly and not just dismissing it and trying to hide under an undue hardship just because they'd have to do something different than they're used to doing. All right, next let's get into some Department of Labor updates. So back in December of 2022, the PUMP Act was passed. Interestingly enough, the Department of Labor is making a really big deal out of this. The press release was on the previous slide, that was in May. They had a webinar just this week for the care industry. They're gonna have another one in January. So they're making a really big deal out of this law. So the PUMP Act requires that when you have nursing mothers, that employers have to provide space for the mother to pump breast milk, and it has to be free from intrusion from coworkers and the public. It has to be available for the mother each time she needs it, and it can't be a bathroom. So the frequency and the duration of breaks is up to the pregnant or the nursing mother for her to decide what she needs for the breaks, and whatever she needs, you as an employer have to provide the accommodation. And you don't have to pay an employee who's taking a break to pump milk unless she's doing so on, like you give people 15-minute breaks in the morning and in the afternoon, and those are paid breaks. If the nursing mother is doing that during those breaks, then you'd have to pay her just as you would the people that are taking the breaks. And the other thing to keep in mind is, and I'm not really sure how you could work while pumping breast milk, but if you are working while pumping breast milk in EMS, then you would have to pay them for that too. Yes?
I used to work in that. Grading papers while pumping, you had to pay them. So if they're checking email.
Oh, absolutely, yeah.
You have to pay them while they're pumping.
Yeah, that's another topic for another day, but yes. I'm thinking of EMS crew members because it's some of the difficulties for EMS is going to be, how do you balance this? Because, well, let's skip ahead. Well, we'll get there eventually. We'll just put a pin in that thought, and I'll get there in a few slides because I don't want to skip over too many slides. But that's the end point is, yes, if they're doing anything at all, and this would go, for people in your billing staff or your dispatchers, if they're taking a phone call or answering a work-related email for 1 minute of the time they're pumping breast milk, then you should be paying them. So think long and hard and talk to your legal counsel before you don't pay them. So there is a small employer exception, but just because you have under 50 employees and might meet what's normally the small employer exception, remember the undue hardship standard. We just talked about that with Groff versus DeJoy. So you still have to comply unless you can show an undue hardship. And this is the most interesting thing that I find about this. So we talked at the beginning of this about how the Department of Labor is making a really big deal. I ask you why. This act is not new. And when this first came out and my whole office is like, oh, we should put out a bulletin on this. This is a big deal. And I'm like, this is not a big deal. This has been the law for years. And I show you, this is the Fair Labor Standards Act from 2020. Look at that if you can see it. It's exactly the same stuff. Everything we talked about, it's there. And at the beginning of this section 207, which is maximum hours, there's absolutely nothing that would limit it to any employer. The rules are what they are that you see on your screen. So this is why I want to bring this to your attention, because while this is not new, the fact that the Department of Labor is making such a big deal out of this and doing like press releases and webinar after webinar, all of you should be scared because they're serious about enforcing this law. And that's the only thing I can figure out is this is one of the new Department of Labor things that they're going to start doing, is making sure that all of you employers out there are actually giving the nursing mothers the space they need. And this is where we get into the logistics, and the hard part is, so you're a small employer. We have to look at the substantial burden. And I listened to the webinar that the Department of Labor did on Wednesday. And yes, the test that they're using, is I did these slides before I saw that webinar. The test you're supposed to use is the same one we went through with Groff versus DeJoy for an undue hardship. But think about it. I mean, in EMS, we're kind of a different beast than everyone else, right? I mean, what about the substations? Like, you've got an ambulance that's stationed at a fire station, and it's the fire station. You're dealing with firefighters, and all they're doing is allowing you to park an ambulance and your crew there. How are you going to give a nursing mother the space she needs that's free from intrusion in a company where you don't control any of the space? What are you going to do if it's a substation, and it's a little substation, and it's like one room and a television, you know? How are you going to give the nursing mother the space she needs? Those are all questions that remain sort of unanswered. I mean, you can use, you know, partitions and temporary things that would shield from view, but how are you going to get, no offense to the firefighters that may be listening, but how are you going to get some of the obnoxious firefighters not to be joking and just open the curtain, since there's nothing but a curtain that's stopping them from intruding? It's all questions that not necessarily I can't answer. The other thing the Department of Labor did was they proposed new overtime changes. Remember back a few years ago when they did them and they went away? Well, they're back. So this came out on August 30th, 2023, and they're proposing to update the salary levels for the white collar exemptions. That's the administrative, executive, and professional exemptions. That would increase the salary threshold for your exempt employees to $1,059 a week, which is the equivalent of $55,068 a year. And there's going to be automatic increases every 3 years. So the other thing they said was that they're going to work the numbers out, and that by the time that the proposal gets finalized, which they're hoping is going to be early 2024, they said that the numbers might increase. And if you're wondering where they base the numbers on, it's apparently the 35th percentile of the weekly earnings in the lowest wage U.S. Census region, which is the southern U.S. So the threshold that they're predicting by the end of 2023 is going to be $59,285 annually, which is something to keep in mind if this goes through, because I'm sure there are some of you out there that have salaried people on your staff that might not be making $59,285 a year. I mean, with the staffing crunches that we've all been experiencing, salaries are raising, but I'm still not sure that everyone at EMS has met that. They project that this is going to affect 3.6 million workers across the U.S. And remember, these are proposed for now, but at least the Department of Labor promises they're coming soon to you. And if you recall, here in Pennsylvania, we did have higher salary thresholds a few years ago. They went away as a result of compromises during the 2021 budget negotiations. But here in Pennsylvania, we did have salary thresholds that were higher than the federal requirements. All right, let's go on to some OSHA data submission changes. This is for the large employers that are out there. It applies to employers that have 100 or more employees in high hazard industries, and EMS is considered a high hazard industry. This change goes into effect in 2024. It's basically, there's Form 300, which is the log of work-related injuries and illnesses, and the Form 301, which is the injury and illness incident report. And if you're a large employer with more than 100 employees in EMS, you're already required to keep these forms, but now you're required to upload them to OSHA on an annual basis, starting on January 1st, 2024. And don't forget, this is in addition to the Form 300A, which is the summary form that large employers were already required to electronically submit. All right, next let's talk about the Pregnant Workers Fairness Act. This is enforced by the EEOC and not the Department of Labor. Or the citation's up here for the lawyers in the group, but it has expanded protections for pregnant employees. You have to engage in an interactive process with the employee and find out what she needs as far as an accommodation. And again, here we go back to the reasonable accommodation absent an undue hardship. And remember what we've talked about so far with undue hardships. The other thing that the EEOC said is you can't require an employee to take leave if another reasonable accommodation standard can be provided. So this took effect on June 27th, 2023. So what I want all of you EMS managers to do is, let's start with the presumption that if you have a pregnant employee, she's perfectly capable of doing everything she could do before she got pregnant, okay? Start with that presumption. And then when she comes to you, or if she comes to you and says that she needs an accommodation, that's when you get into the interactive process. Don't start with the presumption that because the employee is pregnant, she can't. Start with the presumption that she can, but then ask her what she needs in order to effectively continue to do her job. So that's one way to keep yourself out of hot water when trying to engage in interactive processes. Be open when the employee comes to you. You can proactively, when she tells you she's pregnant, say, that's great, I will assume you can do it. You can continue to do your job. If you find that you need any accommodation, my door is open, please come and talk to me. So good way to just keep yourself out of hot water. All right, so vaccine mandates have expired, as we all know. This is the bulletin that came out in July. So on June 5th, they published an update to the vaccine mandate and relaxed it effective August 5th, 2023. So as of August 5th, 2023, the vaccine mandates from CMS went away. So what healthcare facilities had to do now is educate and offer, just like you already do with influenza and hepatitis B. So as you know, the CMS vaccine mandate never directly applied to EMS agencies, but it did indirectly apply because every EMS agency out there that had a facility contract was required to comply with the mandate because the facilities they served complied and they had to prove everyone coming into the facility was vaccinated. So while it went away for the healthcare facilities, my one caution for all of you is just because the mandate went away doesn't mean that the facilities can't continue to voluntarily on their own decide, you know, that was a good idea, I think we'll keep this up. So do be aware that some facilities that you're serving may continue to enforce a mandatory vaccine requirement if you have a contract with them. So the other thing that this rule requires for the healthcare facilities is to make sure that you're keeping records. And even though the vaccine mandate doesn't apply to you, I would encourage everybody in the room that's an EMS agency to make sure that you're tracking the vaccine status for COVID-19 of your staff. Make sure that you're offering it and making it available to your staff and that you're educating them on the benefits of it, and make this part of your organizational safety plan. You don't have to mandate it unless the facilities are making you, but do keep records and try to offer it to the employees just as you do hepatitis B and influenza vaccines. All right, next let's talk about volunteer staffing issues. So far we've been talking about new changes to the law. There is absolutely nothing new here, but this is something that I see all the time, and I want to make sure that everyone in the room understands this. So let's start with what is a volunteer. Every one of these statutes that you see has a different definition for volunteers, and you can't just rely on one of these. You have to look at all of them as a group. So one of the things that passed recently in Pennsylvania is there's a municipal volunteers of fire companies and nonprofit EMS agencies that specifically codifies several things that municipalities can do to provide incentives for volunteers. One of these is a length of service award program, and this is sort of like a 401k for volunteers. It provides retirement benefits for people that are active volunteers. And with the LoSAP programs, you can have both the EMS agency doing it for itself, or the municipality can do it for the EMS agency. The other thing that this law passed was it permitted the municipalities to offer income tax credits and real property tax credits. So these are all things that wouldn't be income to the people because the municipality is providing it, and it's not giving them cash, it's basically saving them money on their taxes and giving them retirement benefits, which is all stuff that the IRS has blessed. All right, so one of the other definitions is the workers' comp definition of a volunteer, which basically says that any member of an ambulance corps is a volunteer. Then there's the Department of Labor's definition of volunteer, an individual who performs hours of service for a public agency for civic, charitable, or humanitarian reasons without promise, expectation, or receipt of compensation for services rendered. So with the Department of Labor, you know, all of us are struggling with volunteers. You know, how do we get new ones in the door? How do we keep the ones that we have? And, you know, struggling then with how much, you know, partially funded, partially paid staffing, which is a combination of paid and volunteer staffing, and then fully paid staffing. And more of us are going fully paid staffing, but trying desperately to hold on to what volunteers we have left. So we talked about all the stuff that they could do, but let's go through some Department of Labor considerations. So there are volunteer incentive programs that a lot of EMS agencies are offering, which is, not just the LoSAP stuff, which is the department, the IRS is specifically blessed, state law is blessed, but they're offering things like cash and non-cash incentives to try to keep the volunteers. But if you do this, are they really still volunteers? So according to the Department of Labor, you can give a volunteer expenses, reasonable fees, nominal fees. You can reimburse them for out-of-pocket expenses. You can help provide payment to reimburse them for materials and supplies. You can even give them benefits like healthcare benefits. So under Pennsylvania law and for Department of Labor purposes, reasonable benefits would include length of service award programs, the income tax credits, the real property tax credits. It would also include free pass, pool passes, or movie passes, especially if you can get those to come from your municipality and you're not giving them yourself. It would include plaques, honors, and awards, and reasonable benefits would also be picnics or banquets. So the Department of Labor's opinion on this, which is sort of the standard today, came out in 2006. And it's the 20% rule that every one of us are pretty well aware of, and it basically says, the Department of Labor says that a volunteer is still a volunteer as long as you're not paying the volunteer more than 20% of what you'd have to hire a full-time employee to do the same thing. But, here's the big but. That's where most of us have stopped, and that's why I'm standing up here doing this part of the session, because I want you all to understand what the IRS says about this and make sure that if you offer cash or non-cash incentives to your volunteers, that you're doing it with full understanding of the IRS rules on this subject. So for the IRS purposes, gross income includes all income from whatever source derived. It includes fees, fringe benefits, similar items, and not reimbursements for actual expenses. So the volunteers can deduct expenses that they incur, but only to the extent they're not reimbursed at all for these expenses. So volunteers who do get benefits like cash payments or non-cash payments have to report these on their personal income taxes. So with federal withholding taxes, you have W-2s and you have 1099 miscellaneous forms. So obviously employees get W-2s and 1099 miscellaneous forms go to people who are independent contractors. And these would be people like, gardeners, because you don't control the gardening of what they're doing. It would include snow shovelers, because you're not controlling the snow shoveler. But the IRS defines an employee as an employee under the federal tax definition is someone who you have the right to control the manner and the means of what they're doing and how they're doing it. And even if you don't exercise that right. So think about it in EMS. You have to control every aspect of what those people are doing that are volunteers for you. How do they go to the call? How are they treating patients on the call? What are the protocols they're following when they're on the call? What are you doing if they don't follow the protocols? You're controlling every aspect of the volunteers that are going on calls for you, which means if you pay them anything at all, you've turned them into employees for federal tax purposes. And this would even include non-cash incentives that they receive, because you as an employer have the right to control what they're doing and how they're doing it. So then you've turned them into a volunteer for federal tax purposes, which means what? Yes, if you've given a volunteer anything above and beyond reimbursing them for their actual expenses, then you need to give them a W-2 for what you're giving them for that cash or non-cash thing. And if you want to read more about it, this is the website. The IRS has it's called Issues for Firefighters, but it also talks about EMS, and the same rules apply for EMS. So the other thing to keep in mind is the workers' comp aspect of this. And municipalities are not throwing cash our way, but they're required to provide for workers' comp benefits for the volunteers. So the one thing I want you guys to exercise caution with these volunteer incentive programs is if you're giving a W-2 to your volunteer because you say, all right, big deal, they're still a volunteer for Department of Labor purposes, I can live with that, I'm just going to give my volunteers a W-2 and move on. Well, that's great, but when the municipalities are tightening their budgets and getting pushback from their residents on not wanting tax increases, and the budgets are getting tighter and tighter, and you're giving a volunteer a W-2, if I'm the municipal solicitor, I'm gonna be lobbying hard to say, these aren't these aren't volunteers, you've just given them a W-2. What's the difference, you know? So please exercise caution and talk to your legal counsel before you implement any type of volunteer incentive program. All right, next, the Department of Justice has a new initiative, and this one has been surprisingly flying under the radar, and the people that have come to me, most haven't really even considered this, but throughout the US, the Department of Justice has been holding informational meetings on the ADA's effective communication requirements in healthcare settings, which does include ambulance services. So pursuant to the communication from the Department of Justice, healthcare providers are required to ensure that people with disabilities can effectively communicate with their healthcare providers just as easily as people without disabilities. And they're required to furnish appropriate auxiliary aids and services. So this is fine for if you have an appointment with the radiologist that you make 3 weeks from now, and I say I'm deaf, I'm gonna need an aid, or whoever's making the appointment for me says that. But what happens if you have a call at 2 a.m. for somebody that's having a stroke and they're deaf? You have to, as an EMS agency under this new initiative, be able to provide that auxiliary aid in sign language for the person, just as if you would for people who don't require that. So you all need to make sure that you have contracts in place with sign language interpreters for the deaf and hard of hearing and stuff, because the Department of Justice is expecting you guys to have these available whenever they need it. And they're saying that it's not okay to rely on, like if you're deaf, to just write things down on paper to communicate with the patient. And they're saying it's not okay to rely on family members to interpret, that they expect EMS providers and all other healthcare providers to have sign language interpreters available. And they're actually, like I said, going around the country talking to people. I've had a couple of clients that have actually gotten warning letters from the Department of Justice because they didn't provide the sign language interpreter when they had a serious call, and relied on the patient's family to interpret for them. And this is a specific thing that was in one of the Department of Justice's communications on this as an example. Failure to provide sign language services for emergency medical services and/or services provided outside of business hours. So do be aware of this issue and start proactively thinking about how your EMS agency can adopt some sort of ability to have sign language interpreters if you're deaf. And last but not least, and this isn't out yet, but OSHA promises that in early 2024, they're going to be issuing workplace violence rules. So be aware of that, because as we all know, EMS providers have been subject to a lot of violent behavior, and since the pandemic, it's been increasing a lot. So it did make OSHA's radar, and OSHA promises that there's going to be some sort of a rule on workplace violence. It'll be interesting to see how that plays out. Any questions? Oh, yes.
The issue with accommodations, and specifically if you have a female provider that comes to you and says they're pregnant. And you make some reasonable accommodations, let me know how things are progressing, when do you think you want to come off the truck, etc. How do you handle if the provider goes to you and says, I want to work up to my due date? Now, that's the first question. The second question would be, they work up to their due date, they go out on a call, they get kicked in the stomach, they lift something, and it causes a spontaneous abortion or pregnancy, there's complications. So the agency made the accommodations and tried to make the accommodations, but that person was adamant about working up to that specific date. What does the agency do?
Well, the other thing to keep in mind to answer your question is pregnancy is, well, you can't treat a pregnant EMS provider any different than you treat any other EMS provider, which is why I started out with saying treat them equally and assume they can do the position and let them come to you if they can't do the position. And it's one of those risks that you have to do as part of doing business, because if you start with the presumption that a pregnant worker can't do her job, then you're discriminating against that pregnant employee. So you need to make sure that you're treating them the same as you did before they came to you and told you that they were pregnant. And as far as liability for getting kicked in the stomach, I would say it's no different than having a non-pregnant person get kicked in the stomach and having a hemorrhage, that causes them to go to the ER. And, yes, there's potentially a lot more trauma with the mother, but at the end of the day, it's your liability, and it's one of the reasons that you pay insurance premiums.
Sorry, I guess what I'm getting across, agency did do due diligence accordingly, but now all of a sudden, employee sues employer, well, you should have took me off, this is what occurred because of, not taking me off the truck, but as long as you have it documented, if we did this stuff.
Yes, document, 'cause you gotta write it down.
And I guess this is another touchy area. The agency require the employee to provide documentation from their doctor stating it's okay for them to go up to their due date, or, I know it's a big legal question, I have no problem, I don't think anybody has a problem accommodating, but I just look at the back end of it. You do this, you allow them to work up to their date, and all of a sudden, something occurs and they try to push it back onto the agency, why, my child's deformed, I have all this other stuff. And then, you should have took me off the truck when but.
Are you making everybody else in your organization that has medical conditions provide notes from their doctors as well? The key is consistency and treating every employee the same regardless of how they present themselves to you. And if you have an employee that says, yes, I'm pregnant, yes, I can do my job, then you document the conversation, the date that they talked to you, and the fact that you told them, all right, if your circumstances change and you find that you need or want an accommodation, you come talk to me. But I mean, personally, I don't think as an employer you should be asking the employee to present a note unless you really want to backdoor yourself into an accommodation that's currently not being requested. I mean,
If I may, it's a workers' comp claim.
right.
And once you accept workers' comp, you have your right to sue. Is that right?
I know I don't want to drag this out, I support anybody, but I guess what I'm looking at is if something would occur, we made reasonable accommodations, and we have that open door policy for that individual, just like, you're on duty, you make the accommodation, something occurs. I'm just saying beyond your control. And now all of a sudden, the employee comes back onto the agency, but you didn't do this. This is what occurred. I guess that's what I'm looking at. And I guess, I guess it's one of those wheels you can just keep spinning and spinning and spinning, and, at the end of the day, you can sue anybody, but
Right.
you could have everything in place and then just something goes wrong.
Right, I mean, remember, McDonald's ended up paying millions of dollars because they served hot coffee. Although, apparently Wendy's got out of paying millions of dollars because they served hot chili, even though they were sued for the same thing because Wendy's was able to prove that you have to have chili at a particular temperature in order for people not to get ill. So the best thing you can do to protect yourself, treat everyone equally, and document things. Whenever people come to you and tell you, I need an accommodation, I don't need an accommodation, the more documentation you can have to cover your butt, the better off you'll be.
And just watch their performance level. If it goes under what you require for everyone else, then it's a performance issue. It's not an ADA, it's not the pregnancy. We've noticed your performance is not where it needs to be. Is there anything you need to ask of us at this point? You don't even mention that it's an accommodation.
Thank you for that.
A quick addition though, because in Matt's question a couple of times, the issue of the employer's liability, if the employee continues to work, say if they're pregnant up to term or whatever, could that fall back on the agency? And then Carolyn, who's a nurse attorney, mentioned workers' comp. That's important because the employee cannot sue the employer. for liability in that case. The workers' comp system is a no-fault strict liability system where the employer's liability is limited in return for the fact that it's not liability, it's not tort-based, right? So there's no risk of the employee bringing a lawsuit against the employer for any kind of negligence in allowing them to work or not making the work conditions safe. That would all be remedied under the workers' comp system. And when Christy said that's why you have insurance, that's kind of part of that answer as well. So it's important to clarify that.
Thank you, Christy. I have a question about like interpretive services. If the Department of Labor specifically, and you're probably going to say, go back and do your homework, Ryan, right? Have they talked about permission for like applications that you can use in the field? I know, you know, some providers who are providing services in areas that have a lot of Spanish-speaking patients will use apps to communicate with patients. What about translation services for like sign language? Do you know if they've spoken to that at all?
They have. They have encouraged providers to get contracts with those types of providers. I don't believe that they've endorsed any specific entity, but they have encouraged everyone to make sure that they have contracts with sign language interpreters for when they go to calls that involve deaf patients, and that they should be available 24/7.
From online, Christy. Would non-W-2 or W-2 volunteers need to be covered by professional liability or malpractice insurance of the provider? And if not, would they have to provide their own coverage?
Volunteers should be covered under the EMS agency's insurance policies. And if you've got volunteers, make sure that you're discussing with your insurance agent what your staff is comprised of to make sure that you have the liability coverage that you need.
There was a second question. When these requirements are instituted, are there considerations on how these services would be funded?
Probably not. I doubt it. I mean, your EMS agency, you've got bottomless pockets, right? You know. No, they're required to go into what the cost of this is going to be, and in my humble personal opinion, they tend to do a really lousy job and don't look at all the costs and they look at the direct things and not the, like, what follows after that, or they leave a whole sector of something out. So usually what they think the costs are and not anywhere near what they actually are, in my humble personal opinion.
Any other questions for Christy from anyone here? For topics or? Okay.
Thanks, everyone.
I'll give this back to you. So, you know, real quickly, the last point that Christy made to put on your radar, the coming workplace violence rules. You know, I know that when we are awaiting a regulatory initiative, right, we sort of sit back and say, well, let's wait till the regulations come out and then we'll, you know, work on compliance at that point. Remember, you know, EMS practitioners are exposed to a wide variety of risks in the workplace, whether paid or volunteer, and whether that's communicable diseases, whether it is, you know, COVID, whether it is hazardous materials, or whether it is workplace violence, right? Those are all foreseeable known risks. And, you know, while we take barrier precautions and infectious disease precautions and we train for hazardous materials and those other things, the exposure of our workforce to violence really is not something that should wait until the government hands down the rules, right? I mean, if we also talk about recruitment and retention and the need to be able to retain employees, I think a competitive advantage when more of the workforce votes with its feet, right? I'm going to go to another organization or another employer to work. The things that our organizations do to show that we care about our workforce, whether it's employee health and wellness, whether it's mental health, access to mental health services, whether it's the training and the resources necessary to prepare them for the possibility of workplace violence. I think those are all things that give us a competitive advantage in recruitment and retention, even while we're sitting and waiting for OSHA or the Department of Labor to regulate the workplace violence standards. But that's obviously something that's coming, and I wanted to mention that. There was one other point I wanted to mention, and I'll turn you loose for our lunch here in just a second. You know, earlier when we were talking about the legislative panel, which, I mean, there's been so much good information here, but I think next year we have to expand that legislative panel. Corinna will make a note for a little bit more time, because I think there were still a lot of good questions and a lot of implications, right? And I just couldn't help but seeing, again, back to Steve's such a unifying message about what the future holds. When we talk about individual bills to reimburse EMS for the cost of readiness, like Gary was talking about, or treatment without transport, like we heard talked about as well. You know, all of these things are necessary, again, to realize that vision. As long as our revenue and our reimbursement is tied to transport as a unit of reimbursement, the system can evolve, because the built-in incentive is to transport, or otherwise we don't get paid. But that is a subset of what we do and what we should be doing. And if we're going to do truly community-based care and not just a ride to the hospital, reimbursement has to recognize that what we do is healthcare. And that also answers the question about whether we're public safety or public health, right? When we go out into the community and deliver healthcare, we deserve to be paid for those healthcare services, whether or not there is a ride to the hospital. So these bills that come up in a vacuum, about paying for this and this fee schedule and reimbursement for that, at the core, it recognizes that a robust emergency healthcare system also involves the delivery of community-based care that we need to be paid for, so that future that Steve talked about can become a reality, right? Payment drives that. So these bills that we talk about are not just, oh, nice, couple of extra dollars in the system. They are all integrated to help the system realize that vision of how we deliver care. They're all pieces of that. And what a unifying message that you delivered, and the pieces of that we heard that all go into that. This stuff all fits together, and it's important to see the system in that way. So on that unifying note, I wanted to now tell you that your reward for all of this is that we have lunches out here on the table and some drinks. Grab those. You can come back in and eat here or wherever you're comfortable. And we will start again at 12:30 for the closing keynote for our symposium this year. So enjoy lunch, and we'll see you at 12:30. About ready to get started again for our last presentation of the day, our keynote address by Matthew Konya, Doing What Is Right, Ethical Leadership in EMS, and there was more there, it got cut off, and the law. Matt Konya is a 2017 graduate of Widener Commonwealth Law School. He is a senior attorney at PWW, at Page, Wolfberg Wirth. I also have to add that Matt was a student of mine in my health law class, which I've taught here at Commonwealth Law as an adjunct professor for about 20-some years. And I had him, I think, in your second year? Third year. So then I saw him at graduation roaming the halls, and I said, what are you doing after graduation? He's, well, I'm going to study for the bar, and then I'll look for a job. And I said, well, give us a call. You know, this was May, graduation. I said, well, give us a call after the bar in, August, and we'll talk. And I think Monday he called, and he's been with us ever since. So we have been delighted to have Matt Konya as an attorney at PWW. His practice areas really encompass the range of what we do at PWW, but I'd say Matt has developed a particular expertise in the administrative law side of our practice with agency regulation, agency enforcement actions, and similar types of cases. And he's been fairly busy in those kinds of cases. So please join me in welcoming for our keynote for this year's symposium, Matt Konya.
Thank you. All kind words.
I just have to add a little bit onto the story of how I got hired. So the email was sent on Monday, but I don't think Doug or anybody at the firm actually knows this. I recently got married, and one of the guys at my wedding party was one of my students that I worked with all throughout law school. And the Monday after graduation, I showed him an email I had typed up for Doug and said, can you proofread this for me? Because I just want to make sure it looks good before I send it. And he handed me back my phone, and I realized he actually sent the email. And I said, John, what did you do to me? He goes, it looked good, and you probably fret on it for another couple hours, so I just did it for you. So that's how I actually got hired. So we're going to talk about doing what is right, ethical leadership in EMS, and because this is a law CLE, the law as well. So some of the things we're going to go over are the similarities between EMS and the law as a profession. We're going to talk about current issues that face both professions. Then we're going to get into the nitty-gritty. What is ethical leadership? How do you lead ethically? And then finally, the positive impacts of ethical leadership. So when I started this presentation, my first thought was, holy crap. How do I combine EMS and the law and talk about both of these fields that on the surface seem very, very different in one presentation? Well, after thinking it through for a little bit of time, I came to two realizations. First off, EMS and the law as professions share a lot. Secondly, I'm not really sure what it says about me that I have my feet in both worlds. And when we get through the presentation, you'll understand what I'm talking about. So first off, a lot of trust is placed in both EMS providers and attorneys. Clients come to us with legal matters. That's the most devastating things in their life at that moment, and they need our help. What happens on EMS calls? Every so often, someone calls 911 because they are incredibly sick. I like to say this often. Think about EMS in a vacuum. Someone is calling 911, talking to an individual who they've never met before, and placing full trust that that individual on the other side of the phone is going to send people to help them. When we get there, those people open their doors, say, come on in, help grandma, and never, ever question anything we do. They just go, they're the professionals, they're here to help. That's a lot people place in us. Both professions need critical decision-making skills. Attorneys work under deadlines, we're in court. Anybody who's an attorney went through your moot court presentation your first year remembers the hot bench when people are just throwing questions at you. Well, in EMS, we're dealing with patients' lives. We need to make rapid decisions to figure out, hey, what's going wrong with this patient? Do they need medical help? If they do need medical help, what exactly do they need? What do we need to do? By the way, Steve mentioned earlier the protocols that are 98 pages, I think, is the BLS protocol. By the way, you need to keep them in mind as well, because you need to make your treatments in line with the protocols. Communication is essential in both. I'm not going to belabor this point. I think this is obvious. If you can't talk with people, you're going to have a hard time doing either profession, especially patients and clients sometimes who don't want to talk to you. There are patients out there, they don't want to see you, they don't want to talk to you. I'm sure every attorney in here can also say there's that one client that when you think of them, you go, not their phone number again, this is going to be fun. Both are high-stress environments. Kind of goes back to what I talked about earlier. People call us in emergencies for EMS. Clients for attorneys, they need help with their legal problems. Everything is depending on you. A lot of times, coworkers in EMS ask me, they're like, hey, being an attorney, is it that stressful? I say, absolutely, just stressful in a different way. EMS, we're worried about the patients. Attorneys, we don't always know the outcome of things. We're waiting on hearing decisions, we're waiting on appeals, we're waiting on judgments. It's just the unknown that really stresses me in the legal profession. Both require continual education. We need to keep up on advances in medicine, advances in the regulatory scheme. If you're in EMS, what do the protocols now say? Anyone that's been in EMS for 15 years or more, remember when we were backboarding every single patient that even looked at the floor weird. Now it's, ma'am, think you can get up off the ground? Okay, let's go over to the litter. Legal, we're all here doing a CEU. We're learning, changes in the law are important. We need to be on top of these things. Both of us have ethical responsibilities. Again, this is a point I think all of us can understand. There's ethical responsibilities for attorneys. EMS providers, we're part of the medical profession. We have patient information that we cannot share with others. People place a lot of trust in us. I have patients tell me things that their own families don't know are going on. It's just the trust. So we're going to talk about some issues facing both professions. Just like how they are similar, EMS and the law actually have a lot in common when it comes to challenges facing the field. Also, no leadership presentation is complete without a Michael Scott reference somewhere in the presentation, and here's yours for this one. We have a lack of diversity in EMS and in the law. There's no secret about it. The data is clear on that. There's also high occurrences of burnout. Talk a little bit later, burnout is dangerous to both the legal profession and EMS, and it's dangerous for the exact same reason. Along with burnout, there's high turnover rates. It's not unrealistic to talk to an EMS agency that says, hey, listen, 50% of the people that I onboarded last year are gone. Now I need to train a bunch of more people to fill those shoes. And we also, and this is sometimes a secret that no one wants to talk about in the professions, we have a mental health issue, we have a behavioral health issue, and we have a substance misuse issue in EMS and in the law. It's there. So some startling statistics to kind of highlight these things. I'm not making these up. I didn't pull these out of thin air. I didn't create these for the attorneys in the room. The sources are on the slides. 72% of all EMS professionals are non-Hispanic whites. 86% of all lawyers are non-Hispanic whites. Think of the populations we serve. I'm going to tell you right now, I'm not a statistician. I don't work for the Census Bureau, but I'm going to bet that the American population doesn't reflect these numbers on the whole. We have a problem of not serving the individuals that we serve. When we're in a community and there's a high population of individuals that don't reflect our staffing in EMS or in the legal field, we need to take notice of that. Roughly half of practicing attorneys are experiencing symptoms of depression, anxiety, with approximately 30% of those falling in the mid-range to nearly 20% falling in the moderate severe range. Mental health is an issue in the legal field. This one is really startling. On a 2017 study, they polled 903 EMS workers or EMS professionals. 27.2% of those said they had at least one suicidal thought in the past year. That's 7 times higher than the normal population. Behavioral health is an issue. Going back to Doug's presentation, the body cam footage, I'm going out on a limb, doesn't excuse the action, but there were some mental health issues going on there. Way more than just what was caught on that camera. The problem was the provider didn't realize it, people around them didn't realize it. Rates of EMS clinicians leaving the workforce, i.e. turnover, was approximately 18 to 20%, and for certified workforce, was 18 to 20% for the certified workforce, and 23 to 26% for patient care workforce. Now let me explain this, because this was a really interesting study. They polled the states that required national registry to recertify EMS providers. And they broke them into 2 different subsets. Those who held a certification but didn't actually provide patient care, and those who held a certification and provided patient care. Those who provided patient care were more likely to leave EMS. Another thing that is a kind of a dirty little secret in the room, we have a problem with retention. We have a problem with staffing in EMS. Having high turnover rates, especially for the ones that are actually providing the care, is a huge issue. Same thing can be said in the legal field. Since 2014, firms have never experienced associated turnover over 20%. At the end of 2021, that figure had risen to 24%. Now, there is a graph, and you will notice there's a slight decrease, but that slight decrease after 2021 is still higher than what was experienced in the past. After looking at all these statistics, I came to the realization the problems facing EMS and problems facing the law, they're the same problems. The causes may be different, but they have the same issues. So how do these issues impact leadership? First off, leaders have to deal with the external and internal pressures that these issues cause. Again, said about 20 minutes ago, or 5 minutes ago, I should say, It's not uncommon to talk to EMS leader and say, hey, listen, 50% of the people I brought in last year, they're gone. They either didn't make it through their probationary period, they've gone on to new careers. These leaders have to keep on focusing on training and bringing new people in and recruiting new people, and then also have to not ignore the individuals that are still there. Because if you focus all your time on bringing new people in and you ignore the people you have currently working for you, guess what? You're going to have a whole bunch of brand new people and not a lot of people that have long-term retention. Also, leaders need to balance the needs of the organization against the issues faced by their workforce and also the issues faced by the communities they serve. It's a tight balancing act. One of the biggest issues, in my humble opinion, that face both the law and EMS is turnover. Turnover can have disastrous effects on an organization, whether it's a law firm or whether it's an EMS agency. Simply the cost. How much does it cost to train an EMS provider? Depends on the agency, depends on the level of service, but that's a cost. Every time you lose a provider, you need to pay money to train a new one. Loss of knowledge. Hey, Ernie left. Ernie had 25 years of experience. If it's an EMS call, he saw it, he knew how to deal with it. Now we don't have that knowledge there. So he can't talk to this individual and say, hey, how would you treat this patient? Same thing goes for the law. You have an individual who's been an attorney for 45 years. Their certification number is 0002. They have a lot of institutional knowledge. They can tell you how things happen. Well, when you read the statute, it seems a little weird, but here's what happened back in 1975 when we passed it. When those individuals leave the field, you lose that knowledge. Leads to low morale. If your coworkers are changing on a monthly, semi-annual basis, you're not going to form those bonds with others that are really important to both organizations. You have the impact on culture that leads from that low morale. And then finally, the client-patient relationships. I go to your firm because I've always gone to your law firm. You treated me well throughout the years. I always worked with Attorney Smith. Now, Attorney Smith is no longer there. Guess what? I'm going to find out where Attorney Smith went. I'm going to go to that law firm because I like that individual. Okay, so now we're going to define what ethical leadership is. Ethical leadership is the demonstration of normatively appropriate conduct through personal actions and interpersonal relationships, and the promotion of such conduct to followers through two-way communication, reinforcement, and decision-making. Yay, the keynote is over. Not so fast. Because simply defining what a term is doesn't help. That was words. They were on a slide. They were some academic definition of leadership. But did that mean anything to anybody? Didn't mean anything to me when I first found it. So we need to look at the characteristics of ethical leaders and how they lead. Through this part of the presentation, if you're an EMS leader, if you're a leader at a law firm, if you're a partner at a law firm, I want you to think, what makes an ethical leader to you? And then also, do I lead ethically? What do I do to promote these values? So first off, it's a style of leadership. We've all had really good leaders we've worked with, and we've all worked with leaders that we wouldn't say were the best. The ones that were usually highly regarded were the ones who led ethically and incorporates ethical values and principles into decision-making and action. And it doesn't only consider the goals and objectives of the organization, but it also prioritizes the well-being of coworkers and demonstrates a commitment to moral and social responsibility. If you're a leader and you only make decisions that are best for the organization without taking into consideration the workforce, someone is going to make a TikTok about you that makes fun of you. They're out there. You need to have all those things and keep them in mind when making decisions. So we're going to talk about some ethical leadership characteristics. Some share common characteristics in their leadership style. However, not one is more important than the others. You can still be an ethical leader and be like, well, I have this checklist that I got from this presentation, and I do 8 of them really well, but the other 2 I don't really do that well. It doesn't matter. But these are just some characteristics they share. First off is integrity. You want to make sure that you adhere to moral principles and that you consistently demonstrate ethical behavior. If you're the executive at an organization and you don't lead ethically, if you let things slide, what are your coworkers going to think? Well, if it's good for him, it's good for me. so I'm just going to do it too. That's not how things should work. Fairness. Everybody hates unfair bosses. You need to lead with fairness. Now, I will say, are you going to make every single one of your coworkers happy? No. But the general principle is you should try to make decisions based on merit and avoid favoritism or discrimination. That can really increase the positive views at the organization. Kind of tying and dovetailing into that, respect for others. Ethical leaders value and respect the dignity of all individuals. Understand people that you may lead come at life from a different perspective than your own. They've had different experiences growing up. They've had different experiences all throughout life. So while you may see something some way, they may see it differently. You have to just keep that in mind. Is one way right, one way wrong? Possibly not. But you just have to keep in mind that, hey, people have different views in life. They've come from different backgrounds. Empathy is a big one. Again, going back to the keynote, or not the keynote, going back to Doug's presentation and the body cam videos, there's a complete lack of empathy for the patients. You need to understand coworkers' feelings. You need to have compassion. You need to understand where they're coming from. If a coworker comes to you or someone that you lead comes to you and tells you something, don't be dismissive. Understand that what may be to you a minor problem may be a major problem for them. Kind of the same thing for those of us who is in EMS. I like to say this all the time. The individual that called you at 2 a.m. because they have toe pain, to you, that's not an emergency, but to them, it may be the biggest emergency they've faced in the past 50 years, and they don't know where else to turn. Take responsibility. Take responsibility for your actions as a leader. If something goes well, it can be acknowledged. But if something goes bad, you have to acknowledge that as well. Hey, maybe this may have not been the best choice. I mean, you don't need to stand out there with a banner on the side of the street going, look at the bad decision I made. But you need to acknowledge it to your coworkers. Hey, this could have gone better. This is my fault. You need to encourage that ethical behavior in others. You want to create an environment that encourages and rewards ethical behavior. Hey, you did a good job. You did really something nice. I like how you did this. You approach it from a different angle. You made a good choice here. If you're the leader that only punishes and never rewards, you're not going to have many people following you. Because people need that positive feedback that says, yes, you did a good job. You need to be ethical in your decision making. Consider the ethical implications of your choices and strive to make choices that align with principles, even in difficult situations. I'm not going to be up here and say, hey, leading is the easiest thing you can do. Everyone's going to be happy with you. No, there are times you're going to have to make decisions that nobody wants to hear. Case in point, the EMS agency I work for part-time, they have a mandation policy. If they don't have the trucks staffed, they mandate people and bring them in on their days off. Is it popular? No. Is it a hard decision to make? Absolutely. Does the individual who make that decision let us know, hey, this is something I don't want to do. I'm not happy about this, but this isn't the best for the organization. And then it's also the long-term perspective. A lot of times leaders get caught in the trap of just looking at the short term and not seeing far out into the future. And then finally, this is a big one, willingness to accept changes. I think this can be said for both EMS and the law. Change is hard. People don't want to change. People see change as a bad thing. We have to remove that. We have to look at change as being a good thing. So we have these ethical principles in our head. How do we actually enact them? First off, as a leader, you need to clarify your values. Make sure your coworkers, make sure everyone around you understands where you're coming from. If they understand where you're coming from, even if they disagree with you, they may be able to say, okay, I understand where he's coming from, I understand why he's doing this, I understand why she's doing this and making these choices. Communicate the expectation to your coworkers. If you don't communicate your expectations and then get upset at somebody when they do something that you don't want them to do, is that fair to them? No. They need to know where you're coming from. They need to know what's expected of them. Lead by example. Again, a lot of these dovetail together, but leaders should be leading by example. If you don't want your crews doing something, if you don't want your associates doing something, you shouldn't be partaking in it yourself, because that just sets up a double standard, and people are going to figure that out very quickly. Nothing spreads in a law firm or an EMS agency faster than gossip, especially if it's gossip about a leader. Hey, did you see what happened? Oh my God, I can't believe they did that. Make sure you're leading by example. You want to provide ethical training to your coworkers. Those of us in EMS, think about how we promote leaders. Hey, you're a really good field provider. Do you want to be a division chief? You want to be a battalion chief? Come on in. Do we ever then train them how to be the leader? Because sometimes great field providers turn out to be great leaders. Sometimes they don't. So we need to provide this training. Also provide trainings to the coworkers. Here's our code of conduct. Here's our ethical principles. We want to talk about this. We want to make sure you understand it. We want to make sure you understand where we're coming from as an organization. Clear policies. This kind of goes with everything when it comes to an organization and a business. Make sure there's clear policies. Make sure ethical behavior is rewarded. And also make sure employees understand the consequences of unethical behavior and that the consequences are equal. Proportional responses. If someone did X and you responded with Y, when another individual does X, you should respond with Y. Because if not, it's going to lead to, well, why was that person treated differently than myself? Encourage accountability. Make sure not only you as the leader, but also your coworkers understand that, hey, if I make a mistake, I need to bring it up to somebody. I need to talk about it. I need to say, hey, that was my bad. I shouldn't have done that. Here's what happened. Seek feedback from your coworkers. Every so often, send out a survey. Anonymous survey through SurveyMonkey. You don't need to log in. You don't need to put your email address. What are your thoughts of the leadership of the organization? What are your thoughts of my leadership? Get that feedback. People become very candid when it's anonymous. Now, also be aware when you do that, because it's anonymous, you're going to get the ones that everything sucks, you're terrible. They send it back. But people will also honestly give you realistic feedback on what they feel at the organization. I'll also add, if everybody responds with, this place sucks, you suck, maybe you need to evaluate your leadership style. Consider the impact on stakeholders. When we think of law firms, we think of shareholders, things like that. When we think of EMS agencies, the communities we serve, the patients we serve, what decisions you make have impacts on a lot of people. Think about those impacts on them. Look at it from their perspective. How is this going to affect them? Are you always going to make sure that no one's harmed by your decision? No. But at least recognize that your decision could have negative impacts on some individuals. And always strive for continuous improvement. There's no leader ever that was perfect. Everybody can improve. So always strive to be the next step. Okay, I do this really well. What do I need to work on next? Where do I need to go from here? So lastly, we're going to talk about the positive impacts of ethical leadership. Trust and respect. If you're an ethical leader, people are more likely to trust you, more likely to respect you, more likely to come to you with issues and let you know when an issue arises. Example, I always like to use from my personal experience. Prior to law school, I worked full-time in EMS. I made a mistake one time with a medication dosing. It was very minor, but I knew it was still a mistake. So I emailed our medical director and the chief at the agency and said, hey, I made a mistake. Here it is. Because A, I respected both those individuals, and B, I trusted them. I knew I wasn't going to get fired over a minor mistake, but it was something they needed to know about because of their leadership style. Improve in coworker morale and satisfaction. If everybody has buy-in into the agency, it helps with the turnover, it helps with the burnout. If people really enjoy coming to work, they're more likely to stay. I like to use the phrase, people ask me, they're like, so do you think you're going to be at the firm forever? And I usually tell people, listen, they're going to have to burn the building down to get me out. So I'm going to be there. And it's not because I hate coming to work every day. I like coming to work. I like my coworkers. I like the leaders at the agencies. I like the leaders at the firm. So I want to stay. It enhances decision-making. If you rely on moral principles, if you consider impact on coworkers, it can broaden how those decisions are made, and you can make better decisions with more information, more ethical decisions. That's not only good for the organization, but also good for the people you serve. Improve relations. Open communication, collaboration with leaders, it helps build strong relationships between team members and fosters a cohesive work environment. Hey, everybody cares for everybody at this organization. So I want to come, I want to be my best, I want to help others, I want to work better, I want to make sure I'm doing the best I can do for the organization, because at the end of the day, I know the organization's looking out for me as well. Really important. Boost organizational reputation. This is especially important in EMS and the legal field. If you have a bad reputation in EMS, there's going to be a newspaper article written about your organization. And it's not going to be very nice. When there's an investigation or something, the first thing the investigator is going to do is, oh, ABC Ambulance? Oh yeah, this complaint's probably valid. But if you have a really good organizational reputation, there's a lot of things that are going to improve. Community relations are going to improve. Same thing with law firms. Hey, this law firm, they have a great reputation. I'm going to go to them first because I've heard they're good. As opposed to, these guys, I heard they're typical lawyers. They're like sharks in suits, so I might not want to go to them. Really matters. Get higher performance from your coworkers. Again, coworkers feel engaged. They feel part of the organization. They honestly feel that if they do well, the organization does well, and they want the organization to do well. In EMS, I have worked with coworkers who've had the mindset that the agency doesn't care about me, so I don't care about the agency. That's never a good thing to be in, because that leads to people doing stupid things out of spite for the organization. Reduces your risk. Several times during these presentations, we've heard, well, what's my liability? What's my liability? Ethical leadership can reduce those risks. Unethical behavior leads to a whole lot of problems, both legal and civil. Being an ethical leader can circumvent this, can prevent this, and you save time and money. Nobody wants to pay attorneys to defend an organization because there was an issue at the organization that could have been stopped for free just by a change in thinking. Helps promote long-term sustainability. Again, ethical leaders, they're looking out for the long term. It's just not those short-term decisions. So if they're looking for the long term, they can plan ahead and see things that are coming down the road. Really helps with the long-term sustainability of the organization. Helps promote responsibility on the societal level. Can ensure that the EMS agencies reflect the communities they serve, that law firms reflect the communities they serve. Can ensure that there's a positive view of the firm or of the EMS agency by the society they serve. Personal development. One of the biggest reasons I'm standing here is because the EMS chief I used to work under literally called me into his office one day for my yearly review, said, hey, Matt, everything's going great, but you're fired next year if you don't go to law school. I looked at him and said, haha, Kent, that's a fun joke. He said, no, I'm serious. I know you took the LSAT and you need to get out of EMS. And that's how I ended here. People who are ethical leaders understand that some EMS providers will be EMS for life. Some need to go elsewhere. And recognizing that and understanding that is hugely important, leads to personal development. With that, I think I'm almost exactly on time. Any questions or anything? Oh, good. Any questions online? Perfect. Silence.
Thank you, Matt. That was outstanding. And as you were going through that, a number of thoughts were going through my head. The first of which was I should have had more student presentations when you were in my class. That would have saved me a lot of time getting materials together. I could have had you run through stuff like that. So very good on that. I was also glad I don't think TikTok existed when you were in my class either, so you didn't have the opportunity to make a video of me about that. So I appreciate that as well. And, wrapping this up, I just want, as I've observed this and thinking about a meeting I was at last night too, I think there's a through theme or two that has been here today on that, and it is As Matt was talking about the leadership, Steve talked earlier about innovation and how that plays together. But there's an opportunity for all of us, whether in the bar or EMS, as leaders to think differently about what we do. I mean, we're at a point of change. The pandemic caused certainly a lot of upheaval. Baby boomers are retiring in larger numbers, and that's causing upheaval as well. And it's really an opportunity for us to ask those foundational questions about what we do, what we want our organization to do, what the goals of it are, and then focus ourselves on that. It's not about, and there may be different ways of doing things that lead us to a different place. And so it really takes some courage, it takes some foresight to keep focused on that. I know here at the law school, over the last 4 years going through the pandemic, the question was, okay, well, what's the focus for the students? What do we need to be doing here? What are we capable of doing? What are we going to have to let go of? Because we don't have the people, or we're not on campus, or whatever it happens to be. How do we get to that particular place? And the other thing, and it came up last night, it came up a number of times today, involves the access, inclusion, diversity, equity, and inclusion and belonging issues. What we do needs to reflect the people that we serve and our clients, because in that, they get drawn into what we do. They'll have better outcomes, better results. We'll be better formed to understand more broadly our greater good, our commonwealth here at Commonwealth Law School. So with that, I'd like to thank all of our speakers today for the great work that they did. I'd like to thank our staff and those that put this together, Professor former Dean Johnson, Corinna Wilson, Brian Fernbar in the back, Paula Heider out front, and all the good stuff that they did on this. I'd like to thank Doug for his continued support of this symposium and his support of the law school. Over the years, there may be a little mini concert over in the atrium here shortly afterwards. And I'd like to thank all of you for coming, those of you here in the room with us and those on Zoom. This wouldn't be possible without you. It gives us a lot of energy to do that every year. And so we look forward to seeing you in fall of '24. So thank you. This is the end of our symposium today. Travel safely.